Uh, would the petition allow?
Allowable.
Appeal is
May I please, Your Lordship? Lordship, I beg to mention for listing of a writ petition, my lord, for admission column. There is some urgency, my lord. Matter has not been listed for many years.
why it is urgent?
My lord, that my lord, matter pertains to my lord, termination of my lord, their my lord, suspension, my lord, withdrawal of termination order. My lord, they are the dates of my lord 1990 teachers appointed in the BSc. Government has my lord formulated policy. In pursuance to that policy, all the similarly situated candidates' termination order has been withdrawn. My lord, the petitioners are the termination order petitioners were not withdrawing. My lord. Thursday, my lord, any date as per your lordship convenience. Next week, my lord.
Next Monday?
Monday, my lord. Well, can it be on Friday, my lord? Friday or Thursday? Because they are my lord, contemplating to pass an order Friday. So can it be possible to on Friday, my lord, or Thursday?
Yes, perfect.
May I please, Your Lordship? Lordship, I beg to mention a writ petition, my lord, for admission. Pleadings are complete. My lord, I am for the writ petitioner. The urgency here is that, my lord, we have challenged the transfer order, which we say it is absolutely illegal. We have joined, my lord, I have joined the new place of posting, but in my earlier place, my lord, my lord, notwithstanding my seniority, my lord, some other persons are now thought to be, my lord, brought in, my lord. That is why, my lord, I am seeking an admission any day, my lord, prior to vacation, my lord, any day, my lord.
Next Monday.
Next Monday. I'm so obliged.
May I please,
Yes.
Your Lordship. Lordship, I'm thank you for listing the motion matter, Lordship. Lordship, earlier occasion it was listed, my lord, but it was left over,
When do you
Lordship.
want?
Lordship,
When do you want?
Lordship on the Wednesday, Lordship. Yes, Lordship, motion matter. Obliged, Lord.
May I please? I beg to call for one affidavit in reply in
My pleasure. I beg to mention for listing, my lord, this is a contempt petition. The without compliance with the court's order, my lord, they are going to publish a provisional list, my lord. I kindly list on 17, my lord.
When
Day
do
after
you want?
tomorrow. 17, my lord. Day after tomorrow. So Friday.
May I please your lordship, my lord? Here, my lord, urgent petition, I want to move on tomorrow, my lord. If possible. Urgent. Because tomorrow, my lord. Because, my lord, it is a petitioner has, all the petitioner has passed the TET examination. Their educational criteria, main educational criteria has been fulfilled. For the additional criteria is that who was reading in, my lord, English medium, my lord, or other medium, they have to take diploma certificate, which was after abandonment, I was accrued this certificate. Subsequently, a similar set of petition was moved, which was dismissed. Subsequently, it was go to the writ appeal, my lord. Writ appeal, my lord, some post has been kept reserved, my lord, for that particular candidate. We filed the petition, my lord. Otherwise, my lord, if the post has been filled up, my lord, my case will become infracted, my lord. If possible. When yes.
May I please, Your Lordship, Lordship, I beg to mention-
Hello, Wednesday one thing, my lord. First up, I have some difficult. Can I add to my?
Your Lordship, I beg to mention for listing of a writ matters for orders.
When?
Any date, Your Lordship, before vacation.
Yeah.
No, Your Lordship, not any urgency, but actually the petitioner's post has not been regularized yet. All the criteria has been
After
the vacation.
on
Any date, Your Lordship, is convenient before
30.
13th.
Lordship, I am praying for listing a matter on today itself, Your Lordship, because here in the petition he has urgency is that, Your Lordship, the petition he has been transferred, Your Lordship. But till date, no such release order has been issued. And the transfer order says that within 10 days, release order need to be taken from the head of the.
After
Then tomorrow, Your Lordship, because the tomorrow is the last date, Your Lordship.
hearing.
Tomorrow is the last date, Your Lordship.
May I please therefore listing a fresh motion matter tomorrow, Lordship. Respondent authority publish the notice to submit the all relevant documents, including the honorable court order also by today itself 5 p.m. Lordship. By tomorrow may be taken up regarding the challenging the appointment OM of the compassionate appointment. Already covered case, there is a various judgments of this honorable court. OM 2020.
The last day.
Today is the last day. Tomorrow, Lordship, they have considered as per information of the client, Lord. For the only for submitting the.
Why not filing? Time.
We have filed on last Thursday, Lordship. Petitioner informed regarding the honorable court order, Lordship, just on last Wednesday. Therefore, they have prepared the writ petition. If that true also, Lordship. That true, please. Oblige it.
May I please? Lordship, I beg to mention for listing, Lordship, new cases, Lord. Newly filed, Lord.
When do you file?
For listing, Lord.
Next.
Your Lordship, one another same pair, Lord. Deep.
May I please, Your Lordship? Lordship, beg to mention item number 9, Lordship.
9.
Lordship. Matter may be kindly adjourned for the day, Lordship.
There by me.
S.R. Nazar Bhuya.
Yeah. Sir.
A.M. Borbuya.
Sir, 1 week.
My lordship, I beg to mention for listing 2 cases. One is relating to pensionary benefit, and one is provincialization of service for admission.
Admission column or motion?
Yes.
In admission column or motion?
Yes, admission
After vacation,
after vacation,
13, 14, 15, you can take any date from
13, 14, 15. 13 of 2 cases. Both under is 15.
May I please, Your Lordship? Lordship, I beg to mention one WPC for withdrawal, Lordship.
Right.
Yes.
When?
Lordship?
When do you want?
Your Lordship, tomorrow? Okay.
My pleasure, Lordship. Lordship, I beg to mention for listing of a WPC Lord. Matter relating to regularization of service.
After
Lord, from 9. Your
May I please? Lordship, last time,
May I please-
sorry, the respectful Lordship.
May it please, my lord.
Yeah.
My lord, I am appearing this matter on behalf of Mr. B. Chaudhary, my lord. As per his instructions, my lord, he has received the instruction from SSA authorities, but the same is yet to be received from the BTC authorities, my lord. So he has prayed for listing this matter on day after tomorrow, my lord. May I pray
Yeah,
for
sir.
listing tomorrow, my lord, on Wednesday, my lord.
Sorry. And if or one. Two. Right. 30. Object. SS.
SSA, my lord.
But
BTC, my lord.
at price of 30 after. Yeah. So, 30.
Please, my lord.
Please, Your Lordship. Your Lordship, in this matter, what has happened, Your Lordship, the petitioner was appointed on the basis of the selection that was being conducted by the selection board, Your Lordship, on the recommendation. And he was appointed in the year 2011, Your Lordship, on ad hoc basis. And thereafter, his appointment was extended, and he has been discharging as a bearer on contractual basis, Your Lordship, for more than 15
Yeah.
years.
Your context of that.
Yes, Your Lordship.
The board has not considered those aim of the aim of the party.
Yes, Your Lordship. Your Lordship, that issue has
For submitting.
no, Your Lordship. I'm submitting that since my long rendered years of service, which I have rendered for more than 15 years, uninterrupted, Your Lordship, against the non-sanctioned post, Your Lordship. my service be considered for regularization, Your Lordship. I'm not disputing that, yes, I'm being not shortlisted is not one of my contention. My contention is that, Your Lordship, I have made representations, Your Lordship, for consideration of my regularization, Your Lordship, for services, Your Lordship, as a bearer, because I have discharged my duties as a regular employee, but on a contractual basis against a non-sanctioned post. Your Lordship, the Apex Court has also held that there is no doubt that if a contractual employee discharges his duties against a non-sanctioned post, but if his duties are so integral to the administration of the respondent's office, then his case should be considered for provincialization, for regularization, Your Lord. That is only my humble prayer, Your Lord.
This is one of your categorical complaints of that selection has not considered the concept.
Your Lordship, I have made that statement with respect to the very issue that since I have participated in the advertisement process, Your Lordship, for the recruitment of grade 4 45 numbers of posts, Your Lordship. So that is why I have made that categorical statement, Your Lordship. But on the other hand, my prayer before this honorable court is that, Your Lordship, since I have made representations before the Vice Chancellor, Cotton University, my case for consideration of regularization be considered, Your Lordship.
You are appearing.
My lord, I am appearing on behalf of Mr. P.D. Nair, who is the standing counsel for Cotton University. My lord, my instructions are that notice may be issued today. We'll obtain our instructions.
Yes.
That may be done. On behalf of Mr. P.D. Nair. On behalf of Mr. P.D. Nair.
From now, context of the take up was appointed here offered by the then or set up at the then was turned of the then there the start like when again here by the then register of the there the register and advertise by advertise that the page was not short or not M by M the advert by the sector take up further some page take up further
Much obliged.
Deeply obliged.
May I his love. My lord,
I was an assistant teacher, my lord. I retired from service on 31st December 2017, my lord. I'm getting pension, my lord. But my lord, I have not received the general provision fund, my lord. GPF, my lord, I didn't receive, my lord. So it's my simple prayer, my lord. This is my lord notice.
Who has to release this amount? The Directorate of Pension or the department?
My lord.
Directorate of Pension.
Director, my lord.
Directorate of Pension.
My lord.
The deputy? Whether CPF amount of the petitioner has not been paid?
It may be, my lord, dispose of the motion space, my lord. Only, my lord, I have filed a requisition, my lord, earlier regarding my pension. And that was, my lord, and the Honorable High Court passed an order, my lord. That is that page, my lord, page 11, my lord. Kindly see page 11. Page 10, my lord, para 5 and para 6, my lord. After I submitted this order of the Honorable High Court, my lord, I am getting pension. Only a small amount, my lord, of 1,64,870 rupees, my lord. The GPF, my lord, amount I didn't get. So that's my simple prayer. It may be dispose of the my lord, motion space, my lord. Directing the my lord, director of pension, my lord, to release my GPF amount.
Deputy?
Yes, your lordship.
Release this amount. The DG or the Directorate of
Um, Lordship may issue notice and may fix a matter in next week, your lordship.
Next.
Okay, next week, Tuesday.
But the Director has not started. Or deputy or
I'm for 2 and 2 only. Your lordship. 2.
When?
1 and 2. 1 and 2.
one and he does for
3F5.
and 5. Common Planet on set up on 7 or Tata 8 the but it's not appropriate. But the of data of earlier. Then it by and order path it the but it but the PPF not yet
The content general. Case number 12. Lordship.
on Monday.
But there is a
Lordship,
letter, my lord.
uh,
Page 12, my lord.
Page
Page
of,
12,
your
my lord.
lordship. Page number 12, your lordship.
page number 12. It seems that the Accountant General Office, because the concern is it is higher secondary school.
AG has to be
Yes, Lord. Because page 12, your Lordship.
judge of the third higher second. The AG has to be notice the from AG third copy.
My Lord, I'll talk with Lordship, in that instance, if it is fixed after the vacation, it will be better. But because my Lord, I want a disposal on page, my Lord. The page 12, my Lord. Let them, my Lord, examine, and my Lord, if I'm entitled, my Lord, I may get it. Because they have written, my Lord. Only see, they have written page 12, my Lord. They have written. Their letter, not my letter. Pension pay as to let it be. On the basis of this letter, my Lord, the statement, my Lord, my petition may be disposed of, my Lord.
Then uh, after some time, let the council, nothing council for AG come.
F2 then, my Lord, F2, because I have another matter. Mal. Good. I know.
May please the Lord. Matter related completion with appointment Lordship. DLC recommended Lordship. Now matter is pending before SLC for consideration. In the meantime, OM has come. DLC Lordship test 31 Lord.
Page number,
Test 31 Lordship. Serial number 1.
serial number
1.
1.
Raza Uddin Yusuf.
Where is the order, the read petition, earlier
Lordship.
order?
Test 20 Lordship. Start from page 20. Relevant page 21 para 3 Lordship.
That's everything.
Yes, your
Let
Lordship.
the matter be placed before SLC.
Lordship, here in this particular matter, your Lordship, that on perusal of page 21, your Lordship,
What is there?
perusal of page 20, it says that directed to place the application of the petitioner before DL district level selection committee on compulsion within 15 days from the date of the receipt of this order, and the district shall on the receipt there will immediately take up the case of the petition and dispose of the same in accordance with in its next meeting or within 5 weeks or whichever is earlier. So this was the specific direction at that moment, your Lord. Thereafter, on that perusal of page 21, your Lordship, it has been shown that were placed before the DLC meeting held on 13/8/14 and 22/6/16 respectively, but rejected due to non-availability of sanctioned vacant posts under compassionate ground. Now the committee has decided to recommend the proposal in the meeting due to vacant posts of are submitted by the DEO Tarang. So taking it into this particular reason or remarks that has been given by the DLC, your Lordship, in many a case when the DLC has rejected or has could not take up the matter due to non-availability of seat, your Lordship. The normal course that is adopted is that they come to the honorable court and thereby they challenge and take order from it. So in this particular case, your Lordship, this different sort of treatment that has been given, your Lordship. So
I may be allowed to take the instruction, Your. Because in some cases they will place the matter again and again till the and more so honorable court's order was specific to place it within 5 weeks, and now it day comes and place it in the 2023 and give pass over the matter, Your Lordship. For sake of parity, I am submitting so.
Oh, the DLC has already recommended
Recommended.
a person to order of this court.
Now the committee has decided
Now-
to
now
recommend the
there has
proposal
been
in the
a
meeting
declared-
due to vacant post as submitted by the and
It has to be placed before SLC now. It's out of the petition. It has to be placed before the SLC.
Lordship,
That
I-
has to be taken.
item 8 similar, Lord. Only date of DLC is different. Name and district is same, Lord.
Lordship, what I'm bothered about is that playing with the order of honorable court in this way or that way. That is what I'm bothered about. To submit.
Yes, 31 recommendation, Lord. DLC recommendation. Item 8. Serial number 6, Lord.
In this matter also within 2 weeks from today. Now the petitioner comes in the year 2025. Order was in the year 2014. So something dark is there behind.
Maybe 23 by the DL.
That is what I'm.
Why it was not placed before the SLC?
No, your lordship. Kindly please turn to page number 20, 21, your lordship. Sorry, page, in case of 8 number petition, it is page number 21. Page number 21.
Yes.
The respondent number 5 is accordingly directed to place the application of the petitioner for compassionate appointment before the district level committee within 2 weeks from today. And on the receipt thereof, the district level committee shall examine the case of the petitioner and take a decision in accordance with law within a period of 2 months.
The authority has failed to consider it within the period of months. How the petitioner is responsible for the same.
That is what I have to get the response from the DLC. They cannot act as per according to their whims in spite of order from this honorable court.
We wait for the instruction, then the date will over. Today is the last date.
Otherwise, also the command judgment says that petitions filed thereafter, before the command judgment, your lordship, they are not to be entertained. But this has been going on, your lordship. That 342/2025 per head, your lordship.
Sure.
Obliged, sir.
Problem.
May please, your lordship. Petitioners here, lordship, all the petitioners were appointed and joined in the year of 2001. Okay? And after the various litigation, lordship, finally in the year 2021, that is page number 74, lordship. Petitioner were granted fixed page number 74.
number
74, Lord. Here the petitioner was granted the graduate pay scale, Lordship, notionally, and while considering their date of joining in the year 2001, Lordship. Here the Lordship, the petitioner name will appear, Lordship. It's serial number 32, petitioner number 1. And Lordship, petitioner number 2 is serial number 36. Petitioner number 3, Lordship, serial number 14.
number
14, Lordship.
40.
14, Lord.
Yes.
Petitioner number 4 is serial number 29, Lordship. Petitioner number 5, 144, serial number.
Yes.
Petitioner number 6, 181, Lordship. And petitioner number petitioner number 7, serial number 9 each. Your Lordship, the date of joining of the petitioner were stated as 2001, Lordship. Subsequently, what happened, Lordship, in the year 2023, the gradation list was prepared for the promotion for the post of Headmaster, Lordship. That is page number 83, Lordship.
Yes.
Considering the date of joining, the accordingly petitioner number 126, petition number 126 name has been appeared in this notification, Lordship, stating the date of joining is 2001, Lordship.
Errors irregularity check. After addressing errors irregularity, please quickly prepare.
Lordship, 83, Lordship. Page number 83, Lordship. That is, Lordship, draft gradation list of eligible teacher for promotion of the post of Headmaster in provincialized school, Lordship. From the page number 84, it starts the list of the teachers, Lordship, where the petitioner's name also were included. Petitioner 1 to 6 names were included. However, the petitioner name was not included in this gradation list, Lordship. Subsequently, on Lordship 18/3/25, another final gradation list was published where the petitioner's name was not appeared, Lordship. All the petitioner's name was not appeared.
Draft gradation list, name of number does not appear.
Does not appear. In the first draft gradation list, the petitioner number 7 was not appeared. And subsequently, when the final list was published, where all the petitioner's name was not appeared, Lordship. Subsequently, Lordship, the petitioner submitted a representation, that is page number 166, to include their name in the draft edition list. But without considering the same, Lordship, on 3/4/25, the process of the document verification was initiated, Lordship, without considering the representation submitted by the petitioners, Lordship. That is 3/4/25, Lordship, page number 170. Page number 170, Lordship. Which may I read, Lordship?
Yes, Lordship, you have to take instruction, Lordship. The verification was started in the month of April. Today is the month of September, Lordship. I think it was already been done. What happened to that, Lordship, I'll have to take instruction. Moreover, so far as
Why the name of the petitioners are excluded from the
that was terminated. So far as my information, because similar cases were filed
Yes.
earlier also, Lordship, where we have also filed affidavit. So I remember thinly, Lordship, that those lists were terminated. Thereafter, the second time the verification, this draft graduation list was prepared. Lordship, that is there, Lordship. That Lordship may kindly give me some time to get the instruction, Lordship.
To my instruction, Lordship, I have stated in the paragraph number 20 also. So nothing has been done, Lordship. No appointment has been made till date, Lordship. And similar,
That is because stay is there, Lordship. The whole process has been stayed.
Lordship,
So they don't have to worry anything, Lordship.
similar matter, Lordship, this Honorable has maintained the has passed the order to maintain the status quo, Lordship.
Yes.
My prayer is to
Now we are not proceeding with this process, Lordship, right now. Because Honorable Court has issued a status quo order. And so far as Sibsagar district is concerned, Lordship, if I am not wrong, the initial draft graduation list that was cancelled. So Lordship may give me some time to get the instruction, Lordship. And we have filed a detailed affidavit in the other cases, Lordship. I'll have to look into those cases also, Lordship. On Friday, Lordship may kindly fix it.
that till then,
This Friday, today is Monday, or next Monday, Lordship.
till then the status quo may be.
Well, stay.
Lordship,
No need to issue any status quo order at this moment, Lordship, because entire process has been stayed. Okay, no? Okay. ये तो हो जाए डिस्ट्रिक्ट अलग अलग होगा ठीक है मैं तो हुआ अभी
easier of higher of the uh, by the draft by number I by letter I by the order
Lordship, appointment orders, Lordship, page number 24. If I have annexure A, Lordship. Starts from page number 24, Lordship.
Here,
It-
that
That is,
Yeah.
initially it was annual temporary basis lawsuit for 15 days only. For that, it was appointment will stand cancelled.
That was fixed, that was initially it was a fixed pay lordship. Lordship after various litigation on 26 to 21,
Annexure
notionally
E, page 74.
page 74, the pay scale, graduate pay scale was gutted, but notionally lordship, considering his joining date as 2001.
it was there, but
Yes, sir.
Yes.
Initial join.
here, it was here. From the
Wait.
Hoja district.
within the almost what up of that all the fight so the fight then for by the for that not for now
Hoja district.
that but you have written here that
Yes, lawsuit. That is why I was confused, lawsuit. Actually, it is Hujai lawsuit.
Now
doesn't feel something that earlier of the murder fight
On the same subject.
on the things of
And here I want to get a specific instruction, look.
and that's the better first of the the record has operated like by the that data for how was
Yes, Lord. Obliged.
at least lordship still in status quo may be maintained lordship. Earlier, there was one petition
So the
for change.
entire process in throughout Assam, we have been stopped for a time being. Yes.
is something that it is said by the
Can go back.
Negligibility. This pension proposal was objected, my lord, on the allegation of some excess royal on the part of her husband, my lord. That, my lord, husband being, my lord, on the part of her husband, my lord. Husband was, my lord, the headmaster of ME Madrasa, my lord. During his service period, my lord, the scale was, my lord, there was allegation of excess royal of scale. My lord, regarding this matter, my lord, that is state of Punjab versus Rafik Masih's case, my lord, that the guideline was also framed, my lord, that in case of grade 3 and grade 4, my lord, that the recovery is not permissible, and if it is lapse of 5 years, then also, my lord, is covered by that case, and there are several cases passed in our high courts also, my lord. Your lordship may consider, or my lord, issue notice that and next that, or your lordship may even dispose of if my learned friend agree.
No.
Yeah.
Not.
Okay.
Okay. A short date may fix, my lord.
Yes.
You will confirm, my lord.
Yes.
My lord.
Pardon?
A short date maybe you should, my lord, let me have confirm.
Yes.
Regarding
Ready for the number?
Yes.
Yeah.
I am for respondent number.
Right. White. Royal. Over. Over. White. And six. Four. And two. Third. Enter the author of
immediately after my
party.
May I please, Lord? My lord, the salary of the petitioner was stopped. Petitioner was service was provincialized as tutor by order dated 5/2/2021, and subsequently his salary was stopped since 1/5/2022.
Why?
Several, my lord, just a letter was issued. That is, my lord, page 44, my lord.
Yes.
Page 44. It is in the bottom second paragraph, last line. I have the honor to inform you that today it is come to my notice that the service of the Monwar Hussain Ahmed had been provincialized on such and such as tutor of Janakalyan ME School under BO Govardhana, but his name was not recommended by DSR. Subsequently, neither any letter issued to the petitioner nor any order for stop his salaries, nothing. Since then, no salary was given.
It is the fact that your time was not recommended by the DSR.
That is, my lord, on several occasions, my name was communicated by the department from respondent number 232222224, and subsequently it is to director. And
I don't know.
Yes, ma'am.
But the KU that on 38 of that begins that and the service was provided by order dated by
5/2, my lord. 5/2.
5/12.
My lord, 5/2, February, 5th February. Page, my lord, 43.
What you have written,
My lord, it is in my synopsis, it is wrongly, my lord. It is just I noticed it.
why
Well,
but since the provincialization start of the petitioner has not under the fact by that happened for next
Before vacation, after vacation, also, it will be difficult to give a vacation.
of
Yes.
17th, my lord.
October.
Well, obliged. Lord, may I allow just that synopsis, my lord, 12,
That is the process for
my
correction.
lord. Obliged.
Lordship, item 10 and 11, learned advocate general appeal for time being, Lordship. For the item, for the time being. Sure. Obliged.
10 and 11 separate.
Yes, yes. Same.
Just for the timing, my lord, this matter, my lord.
Why?
Senior Mr. My lord, Isotary appearing in this matter, my lord. Item number 12, 19 and 20, my lord.
Lordship has already issued notice in a similar matter.
And stay is also there.
Number of cases.
Yes,
Same
I
thing.
is the similar order.
Two notices and the identical for the fake page. Yes.
Well, let him come, my lord. It's fine, doing it.
The meantime,
For the, just for the timing.
These are the lordship.
Yes. In fact, my lord, I have also placed those orders in the my lord record.
Item number 12.
12, 19, and 20. Obliged, my lord. Okay. Client chair.
This is my cover case. It has already passed similar order. My name was recommended by the DLC on 11/2020. Therefore, go to the SLC. SLC rejected. I have approached this honorable court. Honorable court directed to place the my matter before the SLC. But in the meantime, my lord, the impugn OM come. Matter is pending. Page number 26 is the my recommendation by the DLC.
Page number
26. Lord.
serial number.
Scale number, my lord. Next table, my lord. At 10. Name of the recommended candidate, Jan Jeevan Chetia. This is the petitioner. Page number 26.
10 or 11.
10. Jan Jeevan Chetia. Right side, Lord.
Page number 26.
Yes.
Page number 26.
Yes, Lord.
Serial number.
Scale number 10.
10.
Next. 10. Jan Jeevan Chetia.
Here is 11.
11 is my lord. Honokanti Pame.
How many lists you are having? Every you have received copy.
Lordship, that page 26.
Yes.
Serial number 10.
Here it is 11.
Lordship, on the other side. On the other side.
No, my lord. Next table, my lord. This is the first table. This is the my lord. Proposal, my lord, placed before the DLC. Thereafter, out of this proposal, my lord.
Second table on the other
Second
side.
table. We are recommended.
After 8, 10.
Page number 27.
Page number 26.
26. Next table. In the 11, my lord, their name are my lord, before the DLC. In the next table, they are recommended. 10. Category. Clear. Page number 47 is the my lord.
SLC একবার প্লেস হয়েছে না?
Wait, please. My lord, there are quite a few similar matters pending where interim orders have been passed. The facts are like this, my lord. Till 2014, under the UGC regulation, there was no minimum period prescribed for completing PhD course. But the petitioner herein followed the due process, took the NOC from the college, enrolled in PhD, completed his PhD. Thereafter, my lord, in fact, if your lordship will kindly come to page 84, in fact, the first is at page 62. If your lordship will kindly come to page 62 first. In pursuance of the High Power Committee's report, it appears that you have obtained PhD degree from Monad University on 28/3/2013 and have secured the post of assistant professor by provincialization of the same, depending on this degree. As you know that as per the advertisement, you are to place genuine testimonial against legally obtained degree, whereas you have registered for obtaining PhD degree on 9/3/2011. The thesis was submitted on 28/12/2012 in less than 2 years, and there was no entrance test to no coursework for PhD, which is found to be invalid as per prescribed UGC regulation 2009. Therefore, your PhD is not valid. Therefore, you are charged with misleading the higher authority, etc., etc. I am asked to show cause. Now, if your lordship will kindly come to page 35.
This is the NOC by the college. As per your application, the undersigned hereby provides no objection certificate for doing PhD and also granted leave for 2 years only as per GB resolution. If your lordship now turns to the next page, your lordship will find it is for general information to all concerned that the entrance test for admission into PhD course so-and-so batch will be held in the university campus. Serial number 4, your lordship will find the petitioner's name, Nitu Moni Papa. Now, if your lordship turns to page 38, after the entrance test, I'm granted the admission. As per the result of the PhD entrance test held on so-and-so, we are glad to inform you that you have successfully qualified the entrance test and you are hereby offered admission in PhD program of the university. Now, if your lordship will kindly come to page 39, your lordship will find that the registration is done. Page 39. The registration card is issued. And your lordship will kindly note the date, 9/3/2011. And page 40 is the course completion certificate. Thereafter, my lord, I submitted the thesis at page 42. And thereafter, the viva voce was done, which your lordship will find at page 55. The viva voce is completed on 23/3/2013. At the top right hand corner, your lordship will find the date. This is the viva voce completion. And ultimately, the degree is awarded, provisional degree at page 56. This is 1/4/2013. In fact, there was a controversy regarding whether this college itself was recognized or not. If your lordship will kindly turn to page 57, this is from UGC itself. Page 57. The first question itself, whether Monad University so-and-so is UGC approved or not. And the answer on the right hand side, Monad University so-and-so UP has been established by an act of the state legislature of Uttar Pradesh as a private university in 2006 and empowered to award degrees as specified under section 22 of the UGC Act, etc. And there is a specific in the next page at serial number 7, your lordship will find a specific query is asked. Is the PhD degree from Monad University equally valid comparing to any other central or state government university? And the answer your lordship will find on the right hand side. The degree is valid if the course is conducted in regular mode at the main campus of the university as per the UGC regulation. Now this show cause notice is issued, and which I had pointed out at the very beginning, page 62, and I replied. This page 62 I had already pointed out at the beginning. I replied to this at page 63. This was way back in 2020. Now suddenly, again in page 80, your lordship will find another show cause notice is issued. Every now and then they wake up and keep asking the same question. And here your lordship will find at page 80, my name is at serial number 3. By way of one show cause notice, 19 persons are posed with the same query. The subject says departmental proceeding for obtaining PhD MPhil degree in devious manner. And 19 people are asked to show cause. If your lordship kindly turns the page, at page 81, in the second paragraph, I, therefore, being the chairman of the inquiry committee, direct you to present before me on so-and-so to submit your written reply, if any. Against this, my lord, again I replied, at page 82, I explained this entire position factually. And if your lordship kindly turns the page, at page 83, your lordship will find I have copy enclosed. Your lordship will find all these documents that I pointed out to your lordship. All these documents I have submitted. 10 numbers of documents, all the entrance test, coursework, everything, all certificates submitted. Now, once again, at page 84, after again a lapse of more than 2 years, once again same. And your lordship, this time, your lordship will kindly peruse the language. This time, they have already made up their mind to impose penalty. In exercise of powers conferred by the Assam Services Discipline and Appeal Rules, the undersigned hereby asks you to show cause under Rule 9 as to why penalties under so-and-so should not be inflicted. And exactly same query again it is. So therefore, my lord, in similar circumstances, my lord, if your lordship will kindly listen to us, third show cause on the same subject. And similar show cause notices have been stayed by this honorable court matter. If your lordship kindly comes to page 86, your lordship will find a large number of, it goes on till page 89, 56 numbers of such similarly placed assistant professors have been asked to show cause. My name is at serial number 51, page 89. Nitumani Pathak.
Yes.
If your lordship comes back to page 87, your lordship will find serial number 22, Manos Jyoti Niyog, then 24, Basiruddin Bepari, then serial number 30, Krishna Buragoy, and next, serial number 32, Deepak Buragoy. All of these people, they have challenged, and the orders passed we have annexed. Page 114 is that Deepak Buragoy, and page 115, your lordship will find the interim order. In the interim, the show cause notice dated 15/6/24 issued by the so-and-so to the petitioner shall remain suspended till the next returnable date. And similar orders, my lord, in respect of page 116 is Manos Jyoti Niyog. The order passed is at paragraph 8 at page 118. Slightly differently worded, but the show cause notice has been interfered with in the interim. And then page 119 is Dr. Udip Borua. And then page 125 is this Dr. Basiruddin Bepari. So, my lord, at this stage, my prayer would be, your lordship will grant a similar interim protection and tag this matter along with the other cases.
Lordship, in the last week, Lordship is aware about that number of cases of criminal nature were listed before Lordship. So in those matters, Lordship has not given any stay order. So in the similar line, Lordship, notice may be issued, and in previous occasions also another court, court has Lordship stayed the subsequent notices, but the initial
we are challenging the subsequent notice.
But initial notice, it was not the initial notice was not interfered with, and the direction was given that with the department may proceed with the initial notice. So Lordship, at this stage, Lordship may issue the notice as the earlier cases Lordship has done. So we will reply to that, Lordship. And otherwise also, Lordship,
on 2 earlier occasions, they asked for same thing. We have submitted all the materials. It is nothing but to cause harassment. And I can place the UGC notification. If your lordship will kindly come to page 107. This is the UGC regulation of 2014. If your lordship will kindly come to page 107, it starts at page 100, the UGC notification. If your lordship comes to page 107, last at the bottom, clause 18, the degrees which were specified in the earlier notifications issued on 23/5/2009 but have now been despecified shall be treated as valid in case of the students who have already been enrolled in such degree programs prior to this notification. So even if someone is enrolled, even that is exempted. We have already completed. So under the UGC notification itself, we are exempted.
Okay, third notice
Third notice. Yes, in some of the cases, most of the cases, 2 notices were given on identical sources, and in some of the third notice was also given. So, Lordship, here, Lordship, another issue is there that within 1 year and 9 months, whether PhD thesis can be submitted. Though the 2009 regulation regarding the Lordship, the issuance of the PhD degree says that reasonable time should be there. Whether 1 year and 9 months is a reasonable or not, those things aspects has to be considered by the department.
that provided this guideline.
Yes, reasonable time. Yes, it is there. At page 73, they have annexed.
Reasonable time.
The time period has been used. The word has been used as the aid. That should may come to page 74. Lordship, for pursuing master's degree, 2 years is required. How, Lordship, it is possible that the reasonable time would be less than 2 years?
In converse, the LLM degree 1 year.
Lordship. But this is a research work, Lordship. The degree and research work is, and therefore the UGC has, Lordship, at page 74 clearly states that reasonable time. The reasonable time cannot be, Lordship. We cannot understand that it's 1 year, 9 months, one will submit, Lordship, the PhD and obtain.
How can it years or 3 years?
Lordship, therefore, that verification is going on in Lordship. That committee has been constituted, and Lordship has issued notice. No interference has been taken place in the last. I have placed some orders also, Lord. Yes, in some of the cases, 2, and in some of the cases, 3rd also, Lordship. In only the Lordship has issued notice only those cases.
In fact, my lord, even on facts, if your lordship will kindly come to page 39 for a moment. The page 38, my lord. The date of admission is 8/3/2011. Page 38. At the very top right hand corner, your lordship will find the date of admission is 8/3/2011, and your lordship will kindly come to page 56, my lord. Even on facts, they are not correct. Your lordship will kindly see the date of the certificate, degree one. 1/4/2013. Even on that count, it is I have completed 2 years. The date of admission is 8/3/2011, and the date of the degree is 1/4/2013.
But submission.
And your lordship will find how this 2 years has come is at page 100. Your lordship will find the UGC notification of 2014 at page 100. In the chart, your lordship will find PhD DPhil degree, minimum duration towards the right hand side, 2 years. So only in 2014, this requirement of minimum 2 years has come. Before that, there was no requirement. That is why the 2009 regulation says reasonable time.
Yes. What is the reasonable time that we are, Lordship, now verifying?
In retro,
not only this, Lordship, other cases also, some other anomalies are there, Lordship. So, Lordship, at this stage, my humble prayer is that Lordship may issue notice as earlier, Lordship.
right. Get the
For response number 1, 2, and 3, Lord.
higher or
And 3, Lord.
get lecture part of the by the part 4 part it from another part with equity and part of the part and third main the program on with the register
Registration is at page 39. Now. Date of registration is 9/3/2011.
and uh, program on what for 142 what for
Page 56.
video of here that presented by first
At that time, there was no prescription. No minimum time was prescribed. The minimum time came later on.
the present regulation
That is 2014.
Present notification is page 100. But it came after I passed.
But during the Lordship, while he was pursuing Lordship, it was reasonable time.
for by not of by 2014 or 10 the time at the time of program there was further subset have the with notification only for the not or not for
23/5/2024. Page 84.
with the statement of parties under subset that's granted the notice the five of 5 1 5 how about the software learning? I- uh, the- the third sub- part, that, which of the previous like, expected that it take a second part of also second and third.
Lordship may observe that in no interference with the lordship that initial notice of 2020. That no interference has been made with the initial notice of 2020.
Third for the second and third.
Not.
My lord, item number 19 and 20, my lord. Here, my lord, the notice date is different. 15/6/2024, page 72. Both the cases 15/6/24, my lord. Oh,
Third,
yes, same.
here third notice.
Yes. This is the date of third notice, my lord. 15/6/2024. My lord. Obliged.
Obliged.
May please your lord. This is the present petitioner, your lordship, 8 in numbers, your lord. Their aspirants for your lordship recruitment to the post of graduate science teacher, your lord. Science teacher, your lordship. And your lordship will kindly come to the advertisement, your lordship, at page 25, your lord. 25 is the advertisement, your lord.
Thirty-five.
20. Your lordship, at the top, your lordship will find applications are invited from eligible Indian citizens as defined in Article 5 to 8 of the Constitution of India and Permanent Residents of Assam for filling up 7,249 vacant posts of graduate teachers art, graduate teacher science, graduate teacher Hindi, graduate teacher Sanskrit of the different provincialized secondary school. And we are concerned with your lordship series 2, graduate teacher science, your lordship. Minimum qualifications, your lordship, are given, your lordship. We fulfill that qualification, your lordship. Your lordship may kindly come to page 27, your lordship. Criteria for selection of graduate teacher, art, science, Hindi, and Sanskrit, your lordship will get it. There is a headline, and your lordship will kindly come to clause E, your lordship. Initially, it says that the number of qualified candidates in the TETCAM recruitment test shall be in the ratio of 1:1 of the vacancies advertised, your lordship. And then your lordship may kindly come to page 28, top G. There shall be separate merit list stream wise, art, science, Hindi, Sanskrit in case of graduate teacher, your lordship. So your lordship, apparently your lordship, everything should be, your lordship, considered, your lordship, separately, your lordship. Now your lordship will kindly come to page 37. There is an addendum, your lordship. Page 37. Your lordship will find, your lordship, here, your lordship, they have, your lordship, identified the numbers of posts, your lordship, for each group, your lordship. And then your lordship will kindly find that science has been, your lordship, bifurcated, your lordship. Then general teacher, graduate teacher, mathematics is there, your lordship, which was originally in the advertisement, your lordship. There was no graduate teacher maths, your lordship, separately, but here in the addenda, graduate teacher maths was added, your lordship. And number of posts were also, your lordship, declared, your lordship. And your lordship, what will be the qualification that has also been mentioned, your lordship, for the graduate teacher maths? Graduate teacher mathematics shall have a graduate degree in science with honors in major in mathematics and having physics, chemistry, or biology as a pass course for minor subject in the graduate level course or postgraduate degree in mathematics from a recognized university with honors or major in mathematics having physics, chemistry, or biology as pass course. Now your lordship will kindly come to your lordship, page 39, your lordship. Here, your lordship, it says, your lordship, page 39, clause number 11, for verification of qualification and other particulars of candidates, a draft merit list will be published with a ratio of 2 candidates against 1 vacancy, your lordship. And thereafter, after verification and final merit list will be prepared from the draft merit list as per the outcome of the verification report. As per the merit list, in the draft merit list, ratio will be 1:1. Now, your lordship, when calling for your lordship this document verification, there should be, your lordship, as per this addendum, your lordship, 2:1 is the ratio in which a select list was required to be published, your lordship. And your lordship, we appeared, your lordship. Our marks are there, your lordship. We have mentioned it, your lordship. But while, your lordship, in the meanwhile, at page 52, a SOP was issued, your lordship, by the respondent authority, your lordship. Page 52. Your lordship will find, your lordship, first, second, third, there is a number of zone, your lordship, and then, your lordship, zone-wise separate list of allotted candidates for the post of PGT, GT Science, GT Mathematics, GT Sanskrit shall be provided to you in due course of time. That means, your lordship, each category-wise, your lordship, list is required to be given, your lordship. Now, in your lordship, page 56, your lordship will find, your lordship, the grounds of rejection. We are not concerned with that, your lordship. We are concerned with the last point, your lordship, here. After completion of the verification process, General Inspector of Schools shall prepare a list of candidates who has been rejected, showing the ground of rejection against this rejected candidate, and shall display in the office of notice board for inspectorate, and shall submit a copy of the same to the undersigned for publication within official website, so and so. Now, your lordship, thereafter, your lordship, they have first, your lordship, they have issued a list, your lordship. In list, your lordship, they does not, your lordship, it is not on 2:1 basis, your lordship. 1:2 basis, your lordship. One post, 2 persons' names were not there, your lordship. 1:1 basis, they have issued a, your lordship, list, your lordship, and in that list, your lordship, they have not mentioned, your lordship, category-wise, which is science, which is art, which is, your lordship, graduate teacher, mathematics. These were not there, your lordship, in the list, your lordship. Then, your lordship, after first verification, your lordship will find at page 68, your lordship, there is a second list of eligible candidates they have issued, your lordship. Your lordship will find that they have mentioned the roll numbers and, your lordship, application numbers, and your lordship will find that there is no mention about the category, your lordship. SC, ST, OBC, these were not there, your lordship. Page 68, your lordship. This is the second list, your lordship, page 68. And in fact, your lordship, there is no first list published, your lordship. They have individually called, issued letter to the candidates, your lordship. Based on that, your lordship, the candidates were called for the document verification. Here, your lordship will find that this is a list, your lordship, where your lordship will not find, your lordship, who belongs to which category, your lordship, whether he is science, whether he is mathematics, your lordship, whether he is GT arts, Sanskrit, Hindi. There is nothing mentioned, and neither the other categories, your lordship, ST, OBC, etc., your lordship, it is not there. Then, your lordship, Then they again issued your lordship a final merit list, your final list. Your lordship uh, in the advertisement, they have mentioned about 3 lists, your lordship. First, second, and this is probably the third list of final list of eligible candidates, your lordship, page 102. Here also, your lordship will find the names, your lordship, does not reflect the category in which they were selected, your lordship. Marks they have obtained, your lordship. These are not there, your lordship. And in fact, your lordship, some of the candidates were called in the second verification, your lordship. Like your lordship, one at page 69, your lordship will find. Page 69, Triveni Kaur, your lordship. Page 69, your lordship will find. #15 number, your lordship. Triveni Kaur, your lordship will find. Her name again appear in page 103, third list, your lordship. Similarly, your lordship, there are one Nutanjuti Bora at page 70, your lordship. Her name also appeared in your lordship, page 102, your lordship, in the third list, your lordship. Nutanjuti Bora, your lordship, will find at page 70, your lordship. And 102, your lordship. Nutanjuti Bora, your lordship, will find. The below Triveni Kaur, your lordship. Nirmal Paul, Bobita Hazarika, Ranjana Dev, Subhas, Upasana, Konkon, Sesami, Pratibha, Jyotsna, Mehboob, Rajlakshmi, Nutan, your lordship. There are other names also, your lordship. But in ultimately, your lordship, what has happened in the process, your lordship, the process which advertisement sought to make, your lordship, very transparent by publishing a list, your lordship, where 2 is to basis of 1 is to 2, your lordship, persons will names will be there, your lordship, and it says, your lordship, there will be category wise merit list, your lordship, that if category wise merit list is required to be published, your lordship, the draft, your lordship, list which they are publishing, that should also include that, your lordship. That has not been done, your lordship. Ultimately, what is happening, your lordship, that, your lordship, some of the candidates, our names are found in both, your lordship, GT Maths as well as GT Science, your lordship. Both categories, their names appears, your lordship. And some of the names, persons, your lordship, whose, your lordship, certificates are found to be, your lordship, false, your lordship. In their names are still there, your lordship, whether they have been rejected or not, your lordship, whether their name has been rejected or not, your lordship, that has not been, your lordship, disclosed by this, your lordship. Now, a transparent system means, your lordship, which both SOP and the advertisement sought to make, your lordship, that you make out a proper list, your lordship, as going by the advertisement, your lordship. That has not been followed here, your lordship. Apart from that, your lordship, in the meanwhile, your lordship, we have found a statement made by the Honorable Minister, your lordship, before the press, your lordship, saying that they have not found, your lordship, eligible candidate in 1,487, 1,350 posts, your lordship, of graduate teachers. Now, your lordship, we still don't know, your lordship, whether, your lordship, what is the basis of making that statement, or this includes, your lordship, only reserved category candidates or the general category candidates, who these are not there, your lordship. Now, ultimately, your lordship, these statements, these facts, your lordship, clearly creates doubt about the entire process in our mind. That is why we are before this honorable court, your lordship. They should have, your lordship, first of all, your lordship, they could not have go beyond what is there in the advertisement, your lordship, which categorically stated in the addendum that the draft merit list will, your lordship, include 1:2 basis, your lordship, candidates, your lordship, that they have given go by. They published, your lordship, first this the that is, your lordship, will get it at page 110, your lordship. That's a news report, your lordship, we have translated with the original, your lordship. 110, your lordship, 110. It's a process, your lordship. Same, Your Lordship. Here they belong to arts, Your Lordship.
But yeah, what is the extent of the government?
Government stand is very clear. They are not saying anything about their own case. What we are doing, they are saying. Our stand at this stage, that verification process is still going on. It will continue tomorrow and day after tomorrow also. What he is urging that the list should be published. When the verification process is going on, how can we publish the list? Whether it is a first list, second list, or final list. These are verification process list. If whatever the documents they have annexed. I have received the instructions here right now. This list contains the names of those candidates where the verification is going on. Let us go to page number 70. It starts from 68. Let us come. Second list of eligible candidates for document verification. So the process of verification is going on. This is second list. Then my friend has also annexed the final list of verification. That list also is there in the writ petition. Yes, if Lordship is come for to page 104 for an example. Final list of eligible candidates for document verification. So till now, the process of verification is going on at various stages. Once that is over, then we'll publish the list. Number one. And the most important thing which he has suppressed from this honorable court. Once his case was rejected or her case is rejected, immediately a document is given to them. Now they are trying to find fault with the government process, but they are not saying what is their actual case. At the time of their verification, a rejection slip is given to them. And the ground of rejection is also there. Every person whose case is rejected, they obtain this document at the time of their rejection. The zonal director gives this rejection slip. If they have any grievance regarding their rejection, they can always come before this honorable court saying that they were wrongly rejected. Those cases who have received the rejection slips, somebody has reapplied, saying that you are wrongly rejected us. Those cases are re-verified now. That process is also going on. So there is nothing, no cause of action has arisen at this stage, and their whole intention is to stall this recruitment process. They are annexing some newspaper reports that during Durga Puja, the recruitment will be done. Why all these things are coming up? It is a politically motivated PL to stall the government's recruitment process. Lordship will kindly see how these newspaper reports are relevant for this recruitment. They have annexed these newspapers. We are not going to do anything behind the bar, and it will be, Lordship will kindly see, page 117, 1, overlapping or বাবে স্নাতকোত্তৰ শিক্ষক নিযুক্তিৰ ফলাফলৰ বঞ্চিত বহু যোগ্য. If that is the case, let them come. Number one. And number two, another, page number 111. Durga Pujar সময়ত 12 সহস্ৰাধিক শিক্ষক পদত নিযুক্তি. Wow, they are aggrieved. If 12,000 people, students who are deserving gets a job at the government level, how they are aggrieved? They are interim prayer. They are not saying all these things. They are not coming to this court with clean hands. Their prayer, interim prayer, Lordship will kindly see. They have main prayers there. They want direction. Let us go to their main prayer. Page 100, page 21. Directing the respondent authority to publish the rejected list of candidates showing their ground after each stage of verification. So they want that. This is the individual. Finally, when we complete, they want every stage. They were rejected. If they have any grievance, they can come before this honorable court, or they can go to us. Those who have come to us, we are re-verifying. There may be some mistake. That is why the final list at any stage has not come out regarding the merit list. Number two, what is their second prayer? Direct the respondent to eliminate those candidates whose names appear in two different subjects and to call new for documents verification in their place. How they are bothered? This is not a public interest litigation. What is your individual case? That they have to project. Third prayer, upgrade the petitioners or OBC candidates who have secured more marks or equivalent to unreserved categories. This is not their case which is being argued. Fourth, direct the respondent authorities to fill up the remaining 1, 3 to 5 to posts from where they are getting. The verification process is going on. The minister may have given a statement on the basis of the present status of verification. Tomorrow also there is a verification. Day after tomorrow there is a verification. We do not know the clear picture till now. Then what is the interim prayer? Lordship will see page 23. Your lordships may be pleased to direct the respondent authorities not to publish the final merit list and or not to appoint anyone from the final list. So they are trying to approach this honorable court without projecting what exactly is their grievance, that you stall that process. There is some vested interest which is behind this writ petition. So my humble submission is that if Lordship wants, if their real case is that we have wrongly rejected them, definitely Lordship will issue notice. But at this stage, this writ petition is liable to be dismissed for the simple reason because we have not come to a final stage. The cause of action has not arisen until this moment. We'll publish every list. Now, what is that? Page 56. Last paragraph, which my learned friend was saying. Ground of rejection, last line. Last bullet mark. Page 56. After complete, have lots of last bullet point. After completion of the verification process, the zonal inspector school shall prepare the list of candidates who have been rejected, showing the ground of rejection against each rejected candidate, and shall display it in the office notice board of the inspectorate, and also submit a copy of the same to the undersigned for publication of the same in the official website, so and so. So the verification process, second stage, third stage is going on now. Once we completed, the list will be published. But those who were rejected, they were given a rejection slip at the very time when their case was rejected, so that they can take a rectification exercise or measure. One option is that they can come to this honorable court if we have wrongly rejected them, urging that we have to revisit it, or else they approach us, which most of them have done. So that is the situation. It is still yet to be born. We have to first find out who are selected, who are not selected. Then only somebody can say that I am finally rejected for a wrong ground. But they are trying to stall our process of going for the preparation of the merit list. So that is my case at this stage.
May I, Your Lordship, give thought? First of all, Your Lordship, these politically motivated everything else, I strongly oppose to this, Your Lordship. These 8 students, Your Lordship, the cutoff mark is 66.50, Your Lordship. For graduate science, Your Lordship, they have, Your Lordship, secured 66.25, Your Lordship. Their only case is that if they go by the procedure, Your Lordship, advertisement shows, they may come within the zone of consideration, number one. Number two, they have not been rejected because they have not been called for document verification. Question of rejecting these candidates will come, Your Lordship, if petitioner once they are called for document verification. They have not been called for document verification. That is,
if the process is going on, then
Lordship,
process is still going on.
no, process is still going on. That's why, Your Lordship, I am trying to point out one thing, Your Lordship. The advertisement, Your Lordship, addendum is very clear. It says, Your Lordship, that 2:1. That they have not followed, Your Lordship. In ordinarily, it is the advertisement which will guide the, Your Lordship, subsequent selection process, Your Lordship.
No, the final selection is yet to be published.
No, Your Lordship, final selection list will be there. But Your Lordship may kindly come to page 39 again for a moment, Your Lordship. Page 39. Very clearly it says so. Or verification of qualification and other particulars of the candidates, a draft merit list will be published with a ratio of 2 candidates against 1 vacancy, Your Lord. For verification, Your Lord. for the purpose of verification, they should have published first the list, your lordship, where against one vacancy, 2 names will be there, your lordship. First of all, your lordship, they first list they never published, your lordship. By issuing individual letters, your lordship, they call for the, and secondly, your lordship will kindly see, they have not disclosed, your lordship, what will be the, your lordship, the category-wise selection, your lordship. That, your lordship, these are the candidates call for general mathematics, your lordship, graduate teacher, general mathematics. These are the candidates call for general graduate teacher, science. These are the candidates call for. This is not there, your lordship. And there is no, your lordship, no list, your lordship, which shows, your lordship, how many candidates from ST, SC, OBC, we belong to OBC, your lordship. We have made a specific averment, your lordship, that those candidates from the OBC category which has secured marks equivalent and more than the general category, they should have been, your lordship, adjusted in those category, general category, your lordship. That is the rule of reservation. That has not been followed. The entire selection process they have conducted, your lordship. What we are no, that is what, your lordship. They should have, your lordship, at least, your lordship, they should have disclosed how many ST students they have, candidates they have called, how many OBC, that category wise, your lordship, that has not been followed, although they have mentioned that merit list, select list will be prepared category wise, your lordship. Those are not followed. That is why we are before this, we don't want stalling of the process, your lordship. 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 No, your lordship, so far as reservation party is concerned, that's different, your lordship. That is why, your lordship, I have not, at the first beginning, your lordship, I have not placed that argument, your lordship. But the rest, your lordship, that why have you not published the first list, your lordship, containing 2 candidates against 1? That is not there, your lordship. Let them at least file an affidavit to that extent, your lordship. And we are not, your lordship, the minister's statement, your lordship, it assumes significance unless you come up with a transparent process, lordship. No, that is there, your lordship, but we don't have any option, your lordship. That is why, had they clearly disclosed everything, your lordship, the post they are going to fill up, the number of candidates, your lordship, they have called, then, your lordship, probably, your lordship, this would not have been occurred, your lordship. We only want a transparent process to be followed, your lordship. And if in that process we come within the zone of consideration, our cases should be considered. If it don't come, that matter ends, your lordship. We still feel that if they have followed the process, your lordship, we would have come within the zone of consideration. This is our precisely case. The rest, your lordship, that we are not coming at this stage, your lordship, where appointment were to be given, your lordship, so that we are trying to stall it. That is not the case. The Honorable Chief Minister is saying on 10th of October, the appointment will be given. We have come just, your lordship, just 1 month prior to that, your lordship, so that, your lordship, the appointment process does not suffer, your lordship. Let them at least produce before this court by way of an affidavit, your lordship, that what is the status, your lordship, the point we have raised, your lordship. This is my case, your lordship. I leave it to your lordship, raise your lordship.
My final, still they are not telling the correct facts. Some of the writ petitioners, they have not acquired their qualification on the last date of submission of application. That is the reason why some of them were rejected. They are still not telling the court.
Then let them file an affidavit to that extent.
I have a written instruction.
Let them file an affidavit.
They are still not telling the court what exactly is their case. I have not acquired a particular qualification on the last date of submission of application. My case cannot be considered because few other cases this honorable court has already rejected. I think Lordship has rejected also. That is their case also. And not a single word has been whispered on that respect. If that is not the case, they cannot.
If that is my case, your lordship, then I will withdraw, your lordship, my writ petition.
I was not interfering. So they are now urging that 1:1 should be one parameter. They are urging that the reservation policy is not there. They are writing or not writing. I have not gone through the whole writ petition, but few of the writ petitioners, they have not acquired their qualification on the last date of submission. So there are multiple causes of action here. It cannot come under a single writ petition. Everybody has a different story to tell. The factual matrix, factual background of each of the writ petitioner is different. In that view of the matter, this writ petition is liable to be dismissed. Let them come individually. In one case, Lordship will not decide whether reservation policy is followed or not. They may not be SC or ST or OBC candidates also. We have to go individually to each. Yeah. Unless I am an OBC, how can I urge a case regarding OBC policy or reservation policy if I am a general candidate? So a proper person who is adversely affected, they can only come. That locus is not there with the writ petitioners. The candidates who are not having the qualification on the last date of submission of application, their case is totally different from the what my learned friends are going. So in that view of the matter, let them first clarify what exactly is their case, what is their main cause of action, whether that cause of action exists or it is imaginary at this stage. Then only Lordship will issue notice. I am saying that Lordship may not be pleased to issue notice also. First, Lordship, they have to make out a prima facie case on the basis of each individual facts of each of the writ petitions.
Lordship, so far as your Lordship, probably your Lordship, my learned senior counsel has not gone to my writ petition, your Lordship. All the petitioners here are your Lordship OPC. And we have made a specific averment to that extent, your Lordship. And on your Lordship, we want your Lordship, then we are Assamese medium, general graduate teacher, science, your Lordship, we are. And secondly, your Lordship, if your Lordship, we have not acquired any qualification, your Lordship, to your Lordship, which we should have, your Lordship, before the date of submission of last date of submission of application, your Lordship. To that, I don't have that instruction, your Lordship. If it is there, let them come up with an affidavit, your Lordship, so that I can respond to that, your Lordship. Simply by making a statement, your Lordship, without bringing this on affidavit, your Lordship, probably that will not be fair, your Lordship, so far as we are concerned, your Lordship. We only want, your Lordship, that let them come up with an affidavit, your Lordship, on all these points, your Lordship. There are still, your Lordship, 15 days there, your Lordship, for vacation to come. Prior to that, your Lordship may take up the matter and your Lordship may go through, and then your Lordship may dispose of, your Lordship. This is my humble prayer, your Lordship, before this honorable court.
As Advocate General, Lordship, I don't have to file an affidavit. Lordship may record it that will follow the 1978 SC/ST Reservation Rules and Regulations Act in true spirit and letter. Will follow as per. There is no question of diverting from that or not following that. Not only that, we will also follow the this Physically Challenged Reservation Act also, 2016-1995. Women reservation, every act will be followed. And that is the case in all recruitments. In last 2 years, we have recruited more than 120,000 candidates. Not a single case there is an allegation that we have violated any of the SC Reservation Act or the Physically Challenged Act or the Women's Reservation Act. We have followed everything. Here also, it will not be a different case. Lordship may record my submission. If that is their only grievance, that they are apprehending that we will not follow the reservation policy. No. These are imaginary things coming up.
I am not on reservation, your Lordship. At the first instance, I have not, your Lordship. My point is, your Lordship, that advertisement says 1:2. You have not followed. Advertisement clearly says, your Lordship, that there will be separate list, your Lordship, for science, arts, your Lordship, mathematics, Sanskrit, Hindi. You have not followed. Why have you not followed, your Lordship? That is my case all about, your Lordship. Let them explain that by filing an affidavit, your Lordship.
That stage has not come. Once the list will be prepared, then only this allegation can become valid or invalid or effective or non-effective.
Addendum is very clear, your Lordship. Lordship. Lordship.
Only notice. Yes,
Lordship.
yes.
Before vacation, a date may be fixed.
Lord. 20, Lordship? 24. 24. Deeply obliged.
10 and 11. Your Lordship. Deeply obliged.
ৰায়ছৰ লগত নেকি ৰায়ছৰ লগত হয় নেকি আচ্ছা হা হা
DLC approved, my lord. I was recommended to the post of lower primary teacher. Page 25, lord, would have. Page 25 is the type copy, my lord. And my lord would have the originals, my lord, at page number, my lord, 27, my lord. Prayer for recommendation before SLC to be considered before limited prayer.
In this case, Lordship, recently that SOP has been issued by the government, Lordship.
Today is the last date.
Yes, 15, Lordship. So all the district, Lordship, they have as per given the SOP, Lordship, for submission of the entire Lordship pending cases. Lordship. So that today, the petitioner also Lordship submit the personal department, Lordship. Yes, Lordship. As per the notice.
Yes, sir. SOP I have annexed, last annexure of this writ petition.
He has annexed.
I have annexed, my lord. Executive order.
as-
That is the
yes.
Are you applying again as per that?
My lord, if I get an order from this honorable court
No,
that
no.
my case may be recommended for SLC, then I can send my details along with this court certified order. Then my case, that is the last week also plethora of cases have been discussed.
Also ordered.
Then Lordship, today is the last date, Lordship. Then he will not get the
Okay, I'll
benefit,
try
Lordship.
my
After.
luck. I'll
No,
try my luck.
order is not required, Lordship. Only Lordship.
The number is
Only Lordship, his DLC number and Lordship, his number is he submit the application, Lordship, before the yes, sir.
pass the order. Say.
My lord, previously I had approached the court, my lord. Page 73, my lord would find me, my lord. Page 73 of the writ petition. My lord, WPC 7761 of 22, my lord. I had assailed the minute of the SLC 26/8/22, my lord. This was regarding, my lord, that my father's service, only 3 years service was left. That is why I was deprived of selection on compassionate ground. But the honorable court interfered in the last round of litigation, and I was allowed that my case would be placed before the SLC. Accordingly, I did it, my lord, but till date it has not been done. If it could kindly be considered, my lord, for SLC, my lord, pursuant to the last court orders, last order passed by the 73, my lord. That was me, 7761. Seven.
Yeah, next development company.
Lordship, here in this matter, after this particular order, the writ appeal was preferred by the state, your lordship, and in that matter, the state has obtained a stay, and the stay is now present in continuation, your lordship. So perhaps the hearing is on 14th of October. So many similar matters are there. It relates to that in case of compassionate appointment as per the OM, those persons whose service has been less than 3 years, they were not eligible for applying in the compassionate appointment. As per 16/15/2015, that particular OM was challenged, and honorable coordinate bench was pleased to set aside that particular requirement, your lordship, and thereafter the state has appealed and a state has obtained the stay, and the stay is in operation as on date. So this petitioner, along with similar other, once the stay is this way or that way, he will get the benefit accordingly.
Today my case may be recommended before DSC.
No. Can go. Because if in his case, if your honorable courts directs, then all those matters they will be, because that as the state has stay is in operation as on date. If I furnish that writ appeal number subject to the outcome of that writ appeal, your lordship can.
Yes.
But it need not be placed as on date to the SFA. We have all those matters which have come across in front of us.
Wait till
Yes, till disposal of that writ appeal until October 20. Then parity will be there. My honorable court of DS. Lordship, I'm.
Well, then my prayer would be that it may be subject to outcome of the writ appeal, which my respected senior has just given.
Lordship, I'm furnishing. Oh. Lordship, the writ appeal number is 287 oblique 2023
27.
oblique 2023. State of Assam versus Deepak Gogoi. 2023.
23.
Yes. Writ appeal 287 oblique 2023.
Deepak Gogoi.
Deepak. बहुत अच्छा सीरीज नंबर
Gateway appeal from Devasith.
writ appeal 37.
The order passed in WPC number 1646 of 2021 under section.
Yes, yes, yes. Herein, the annex, it has been annexed 1646 oblique 2021. And series of matters are here. Page number 24. Page number 24.
Wait till the data.
Yes, yes, my lord. There was just one observation. If it pleases my lord, they may be my recommendation may be subject to the outcome of the writ appeal which my senior respected. If in the meantime, my lord, suppose the stay which is there operating, it gets vacated and court is in our favor, I may get the benefit of it.
Definitely, definitely you will get. All of those will get the chance.
Small observation.
Provided the data is
If it is dismissed, then no chance. If it is, if it, yes, yes, yes. Your lordship is.
that is the dispose of
Yes.
Yes, ma'am.
They will be in the same train.
this matter after that.
Yes.
Yes, ma'am. 24.
2014.
My lord, here no DLC recommendation, my lord. Here we had only challenged the 3 years, my lord, of the 3 years service, my lord, regarding the OM. Clause 1 of Office Memorandum dated 1/6/2015. We had challenged.
Yes. I think by one then connect the order. The for on the council. Uh, pass preferred but detail subject or every 14th of
Your Lordship.
next date.
Next date is 14th of October.
October. That's it.
Lordship, maybe in the last part of October, then it will be
7, 70, 70,
22nd of
22nd of August. My lord, if it pleases my lord, item number 22, similar method. Similar like item number 14, compassionate appointment recommended for, if it pleases my lord, we taken 20 or 22. No, my lord, 14. That placed before DLC, then not placed before SLP. 22.
22.
My lord, I was recommended for upper primary teacher post. Similar, my lord. We placed before SLP. Limited period. 22, my lord. My lord, would kindly have my name at page number 21. My lord. Recommended for you, upper primary teacher.
number 9.
Serial number 9 at page 23, my lord. The actual minute. Bondita Gogoi. Prayer for recommendation to be recommended before SS. Placed before SS.
The order of this court.
My lord, the order of this court, my lord would find that page, my lord. My lord would have it at page. My lord, page 18, my lord. 18. And 18 it starts, my lord. And relevant page is 20, my lord. 20. To be placed before the DL.
But this from perusal of the list, that page 22 here. The DLC ought to have given at least the date of death. Because many instances we had come across, the matters of 16 and 17 are not being considered, but matters of 1992, 1998. But that is because purpose of the scheme is immediacy and harness. So that's why I was praying before your lordship that trying the word parity. So somehow it becomes a bit too die.
My lord, this has been issued by the respondent authorities. We have not issued this.
Not the subject matter of that.
Yes, my lord.
That is the
Deeply obliged.
Lordship, item number 16, 18, and 21, similar, Lord.
all are compassionate appointment.
Yes, Lordship. Item 16, Lordship, petitioner recommended by the DLC, Lordship. Page 35, Lordship. Page 35, Lordship. Relevant page 35. Serial number 3, Lordship. Atikul Hussain. 3, Lordship. DLC recommended. Now matter is pending before SLT for consideration, Lordship.
Order of court.
Lordship.
Order of this court.
Lordship, page 21, Lordship.
21.
Yes, Lordship. It starts from 21
16, 15,
And relevant page 24, Lordship.
16, 18 or 15. 21 to 2. Lordship, my prayer is same only, Your Lordship, because they have not mentioned the date of death. That observation, Your Lordship, kindly. No, so in that pretext only, I am asking if a date is being offered to me, if Your Lordship permits me for a date, because I want to that bring into, they have to respond with regard to that, Your Lordship. Why at least the date of death they have not given? Because we have come across that matters of 2007, from 17 the scheme is stopped, 16 and 17 that those persons have not been considered in this or that pretext. Matters of 2002, 1998. However, the scheme speaks about immediacy and harness. So what is the background? Why? Your Lordship can, with Your Lordship's observation, everything can be okay, Your Lord. But in order to, yes. 16.
18, Lordship. 18 and 21, Lordship. District is different, Lordship.
16, 18, 21, 20.
18 and 20.
Only that 16 is of South Salmana. 18 and 21 is of North Lokhim.
DLC recommended as per the letter issued by the Joint Secretary, Lord.
Order of this is Annexure 8, page number 45, in item number 18.
Yes, Lordship. Page 21, petitioner approached earlier, Lordship.
In 18, it is, that is in the year 2003. In 17, 16, 16 to 2004. 2003.
Thereafter, Lordship, Joint Secretary issued letter, Lordship, page 33, Lordship. Annexure 3. Last paragraph.
Where is the recommendation?
Lordship. Page 37, Lordship. Page 37, serial number 9, Lordship.
Permit, sir.
Yes, Lord.
Lordship, that my prayer is that would be that same only.
Next item, 21, Lordship. Petitioner approached earlier, Lordship. Page 29. Yes, start from page 29. Relevant page 31, Lordship. Para 6. Lordship, 19/2023, Lordship. Page 37. Sorry, Lordship. Page 32, Lordship. Serial number 1. Page 32, serial number 1. grade 4 post, Lord. Recommended for grade 4 post. Item 17, Lordship.
17 was
The proposal of the petitioner was placed before DLC, Lordship. Page
Underqualified.
23 relevant page, Lordship. That was rejected, Lordship. Thereafter, petitioner approached before this honorable court, Lord. Page 23, Lordship, type copy, serial number 2.
Underqualified.
Due to under qualified, Lordship. Thereafter, petitioner approached before this honorable court, Lordship. Court order, Lordship, page 31. It starts from page 31, Lordship. And relevant page 33, para 4. Set aside the rejection of the DLC minor, Lordship. Thereafter, Lordship, thereafter, petitioner submitted the representation dated 14/11/2023, Annexure 4, page 42, Lordship, along with certified copy of this order, Lordship. And thereafter, the DEO, Lordship, Hailakandi, issued letter to the petitioner for appearance along with original documents, Lordship. Page 43, Lordship. Letter, serial number 11, Lordship. Sadia Begum Lashkar. Thereafter, DLC has not placed the application of the petitioner, Lordship. Thereafter, he filed contempt petition, Lordship. Page 44. Contempt petition is pending before this honorable court, Lordship. Order is page 45, Lordship. But the petitioner have not challenged the OM, Lordship. Therefore, he filed the present writ petition, Lord. Subsequent OM, Lord. Letter may take with the Lordship.
Or Lordship, in Annexure 8, page 51, Lordship, as per the notice, Lordship. As per
I may be allowed, Lordship, to submit required documents as per notice dated 38, Lordship. That may be.
You have not applied. He has already applied, Lordship.
Applied.
As per his
Or
notice
38, 2025, Lordship. Page 51, Lordship. Subsequent notice. I have applied. Lordship, I have applied with serial number, Lordship. Correction of the place the method for the DLC, Lordship. What the highly applies, Lordship.
May I please? My lord, I just take a lordship to the affidavit reply. I have through this affidavit, I have enacted this rule of admission, my lord. In the page 64. Page 64.
But
He'll come, my lord. I have
sometimes I
May I please, Your Lordship? This is regarding conventional amendment, my lord. Conventional amendment, my lord. The author of the petitioner died, my lord, on 6/1/13, my lord, and petitioner applied, my lord, on 3/3/13. Thereafter, the petitioner's case was placed, my lord, before the DLC on 15/7/14, page, my lord, 26, my lord. Page 26, my lord. DLC on 17 July 2014, and operative portion can see, my lord, page 28. Page 28 is the operative portion. In the bottom, my lord, second last paragraph, line from below, my lord, line 1, 2, 3, 4. And let's got it. In the middle, my lord, 12 numbers of proposal. From bottom, my lord,
for
28, my lord. From bottom, yes, district level committee, my lord.
70.
28. Page 28, bottom, my lord.
Yes.
Yes. My lord, from bottom, my lord, line number 1, 6 number line, my lord. From bottom, 12 numbers of proposal. What you got it, my lord.
Yes.
12 numbers of proposal, namely, my lord, Mainu Bairagi, Dodumuni, Vipul Gogoi, Dipankar Das, Ridip Lahon, Rupam Borua, and Sagurika Gogoi. Sagurika Gogoi is the petitioner, my lord. Sagurika Gogoi and so and so could not be considered due to non having requisite percentage of marks for qualification. My case could not be considered due to percentage of marks, my lord. But my case never been rejected, my lord, by the deal. This was not communicated to me, my lord. Petitioner after came to know, my lord, filed an application, my lord. Page 30. Page 30, my lord. Page 30, petitioner period, my lord. The petitioner case may be considered in any other post, my lord, or any other department, my lord. Petitioner is a higher secondary batch, my lord. She is eligible for, my lord, suppose grade 4 or grade 3, except, my lord, TSR, other post he is qualified. That not been considered, my lord. I have challenged the OM, my lord, in this agency. Yes, sir.
Whether it is a percentage of mark for qualification considered.
Uh, he will be eligible for any grade 4 post. Yes.
he or she. But the aspect here is, Your Lordship, that the DLC rejected it in the year 2014, Your Lordship.
That is not communicated to my lord.
So after this 11 years, Your Lordship.
DLC considering cases of 2003-4, my lord. I have the order, my lord.
That is what
Your lordship, so many decision, my lord.
that I have brought to Honorable Lordship.
Learned friend also, and in my case, my lord, 2013 matter, my lord. 2013, father of the petitioner died, my lord.
17 matter appeal for review for the order.
So they are considering one time measure, my lord. Maybe my case may be considered, my lord, or any other court, my lord. In my case, not rejected. It says, my lord, it could not be considered, my lord. Not rejected, my lord. The DLC.
Could not be considered itself is a rejection.
If the appointment is percentage is nothing,
Not an essential criteria. Because they will be eligible for grade 4 post.
any other department.
In any other department. Yes. In all of the departments. If in that particular specific department it is not here.
My lord.
Maybe adjusted against any other post.
Of this, any other department.
My lord.
That
Four.
that your four.
But yes, that one line submission may be there. Your lordship, please.
Yes.
Published, my lord.
Nice.
I don't want to be
The judgment and order passed by the learned special judge Posco in case number so and so is set aside. Consequently, the sentencing of the accused appellant White, the order dated so and so passed by the judge Posco is also set aside. Appellant is acquitted of the charge under section 376 IPC and section 6 of the Posco Act. The bail bond stands discharged.
Much obliged, my lord.
In the result, we find sufficient merit in this appeal and accordingly the same stands allowed. Convictions and sentence of appellant Pasangta Se stands set aside and was. Consequently, he shall be released from custody forthwith.
Grateful, my lord. Grateful.
Yes, Lordship, the secretary and director, they are both are present. We have already published that list, final list. Lordship may kindly present this.
When?
এটা পাবলিক ডেট তো কিছু আসলে
order to
11 it's 11 9 or 14 9 on 14 9 lordship 14 আপনার ইনস্ট্রাকশন হয়ে দিছে এটা পাবলিক 11 yes it is on 11 9 lordship yes sir.
Can you furnish a copy of
Yes, yes.
the
এখন এই ফাইনাল লিস্ট পাবলিশ করে now for the process of appointment lawsuit it will take some time lawsuit that will be done very shortly lawsuit
Milord, again, there is an explanation but piecemeal. Kind of piecemeal solution they are coming with. Lordship will kindly see. Direction was very clear that within 3 months, that was in the year 2020. That was in the year 2020, the division bench directed that within 3 months, the process of the selection and appointment of these petitioners should be completed. Thereafter, we are in the end of 2025. Today, this petition was filed, contempt petition was filed when? 3 years back.
2 years.
2 years back. No reply till today because of your lordship's order, since they are personally present here. They have come up with the final select list as they say that this is the final select list. If this is so, what prevented them from making the appointment? Considering the delay already done. The delay already taken place. These boys and girls, way back in 2020, came to before this honorable court. They obtained an order from the division bench of this honorable court. They went on SLP before the Apex court. Apex court, on the very first day in Limini, it was dismissed. And thereafter, they did nothing. And ultimately, today, they have come up that this is the final select list. We need some more time again. And a glance in this list, Lordship will kindly see.
They are going to verify 20 again.
Again, this is the final select list. They say, they show some of the candidates. In remarks column, Lordship will find, in the remarks column, they have reflected that their remarks withheld, few. But the status is selected. Kindly see this. Registration WPC, case number has been mentioned in which they were party. Then total marks, selected status, Lordship will find 7th column. Selected, all selected, but in the last column, remarks column, some of them have been shown as withheld. What is the meaning of this withheld? After final selection, that is there anything left again? This is the final merit list, select list.
Why they have some 4 time verification?
How many time verification is required?
4 times.
4th time, I am told that the 4 verifications were done. Obviously, they were taking so much of time to complete the process, saying that this needs some more time, and this court has shown leniency that you do it. Do and complete and come before us with specific, definite proposal and action. Contempt has already been committed. But this honorable court was pleased enough not to issue the contempt note. I'll say that the contempt has already committed. Is there any explanation why they have not done it till the other day or even today? What prevented them from doing? What is the explanation coming forth before this honorable court? Nothing. No affidavit till today. My lord, I really express my anguish. Is this the way of treating the order of this honorable court? It is a serious thing. The other day it fell from your lordship. The 3,000 and more contempt cases are pending against this department. Because of this kind of attitude, which reflects the negligence, deliberate inaction.
Not 3,000, it is 341.
Yes.
340, I stand corrected. I'm sorry. This much of, my lord, kindly see.
This was the national news.
National.
Yes, national news.
National news. In our High Court.
Elementary education department is the highest. 165 cases.
165
That is because
cases.
lordship, in normal case, repetition also very large extent so far the education department is concerned, lordship.
And the oldest case is of 2014.
14. Just see, my lord. This 10 years, 11 years old. So ultimately, my lord, they explore all the possibilities to see that the order ultimately passed in favor of the petitioners gets revised or modified or cancelled. They do all the process they do. No issue there. But after it has been finalized, here is a case where it was finalized by the apex court. Thereafter also they sit tight and do nothing. And when contempt notices, I mean in a contempt petition notice has been issued to explain, this is a preliminary notice. So what happened? You come and just explain before us. We are not looking it from the point of contempt, but you come and explain. That is the purpose of issuing the preliminary notice. And if this notice is not paid heed to for more than 2 years, what remains? And today also, I expected that they will come with concrete proposal. Look, these are the appointment letters we have issued. So it is total compliance. There is no compliance even today.
Okay, Mr. 68.
Yes, your lordship.
This remark column indicates
Those
withheld.
those are of person who are having NIS candidate lordship, National Institute of Open Schooling lordship. There's some corresponding some cases are going on in this honorable court also. So those cases, lordship, we have to make some verification. We are also waiting for some outcome of this honorable court lordship.
But when we can expect the
entire process lordship
completed?
After doing all this, lordship, within a month, lordship, entire process will be completed.
A month.
On the presence of secretary and director, lordship, I'm saying.
Malad,
because there are some court cases also there, lordship, regarding NIS. Those persons who will
probably my learned friend is not properly instructed. He is not properly instructed. Kindly see, this is a case of 2020. At that time, it was finalized. And at that time, there was no question of NISM and all that.
And even in the
and those people, those who were selected that time were already appointed, gone. We, a handful of persons who were the petitioners there, we have been left out. And we are fighting for last 5 years, asking for the appointment on the basis of the court order. Therefore, question of NISM cannot be raised here. These issues are irrelevant totally. They are mistaken.
Issue appointment letter.
Exactly. And thereafter, Malak, if I may just, I'm sorry, I'm interrupting. Courts is open to them. First thing is the compliance of this honorable court's order. If they subsequently find something where from it appears that somebody is ineligible, subsequently become ineligible. If there is a case of such nature, courts is open to them, giving a notice to everyone. But they cannot now keep on pending the entire matter on the ground that this issue is there, that issue is there. These are all issues are discussed and done and finalized and court order is final. Therefore, you issue the appointment letter now. You don't have other options. That's why I say, my lord, they do not have any other option now. to say that because of these issues, legal issues, we have not been able to do it.
Lordship, there is only 50% who has been withheld, whose results has been withheld, Lordship. Apart from that 50, Lordship, 237 will issue before the qualification, Lordship. And let the court decision came regarding NIS in-service teachers, Lordship.
My lord, may I suggest, my lord? This is a notice they have, my learned friend gave to me, I suppose. One.
Before the qualification, 237 appointment will accept.
They say that verification date has been fixed as 28th of this month. Today is 15.
Sorry, 15.
Today is 15. 28th is their date for verification. They say whatever they process they want to do, let them do by that day, 28th of September this month, and then let them issue the appointment orders immediately thereafter.
Yes.
Within a week.
Within a week.
Within a week.
Before 10th of October, Lordship. 20th of September is a verification date. Then after
before vacation, let us not go to that extent. Let us go by them. This is 25th, 28th, they say. Lordship has seen that notice, my lord. 28th of September, they have picked it for verification. Let them do it. Let them do it. And let the matter come up on 25th. By that day, they will produce the appointment letters which have been issued. There is no question of pushing it further back after vacation. Let us give some positive message to the society, the petitioners, litigants, that there is a limitation. This court will definitely extend its hands to the extent possible, but if ultimately there is a limitation, one must have to comply with the order of this honorable court. This strong message is required to be sent. Otherwise, Lordship has realized I need not have to dwell more. I don't blame the persons as such, but the system has become such, which has shown total negligence, disregard to the orders of this honorable court. We have experienced for the last more than 45 years, we have seen it, how things have deteriorated. That should not be allowed to happen. So Lordship will fix it on 25th. By that day, they will come up with the final compliance. Otherwise, Lordship may indicate that we'll have to issue contempt.
This appointment letter,
yes,
the
that
petitioner's report is put on 25th.
Except that 50 those were withheld, Lordship, but rest 237 Lordships. Right.
Verification is made for them on 20th. So otherwise, they can issue the other. They could have issued the appointment letters to the other candidates, even within these days.
Subject to receive satisfactory reply in the withheld cases.
Yes, sir.
Their appointment can also be.
Yes, that is why we are waiting. Let us wait till 25th. They will conduct the verification on 20th and do the.
Regarding NIS, there's a case, the litigation is going on, Lordships. I think the judgment will
already come. Has been removed.
impact the whole petition, Lordship. That is why that is the difficulty we are facing.
This is not applicable here. Even if some orders come
anyway,
up,
Lordship, let it fix on 25th.
even if, let us take it the worst case. Even if some orders have been passed, this is a case which has been approved by the apex court way back in 2020. And thereafter, what remains? Can any plea be taken now? That is why my case is. There may be a case subsequently. And therefore, Lordship will kindly make it specific. That's my respectful submission.
Came also and PD data. Order for 5/9/2025. The secretary part also director. That the final select of the yes, that both five, they will produce the appointment letter of the petitioner before this court, and also the student are appearance of the contempt or dispensed as the matter on 25th of September 5, and the student of the contempt or the appointment letter of the petitioner court
And
is
let
the letter like.
let them be there on that day with the compliance.
No, if they produce the order, appointment order for their presence, will not be
May not be necessary if they do it before, but otherwise,
We have already issued, published the final
otherwise,
list. There is no delivered so
because
far as this correspondence are concerned, Lordship.
my lord, my question is, as I have submitted, by not doing anything, no having given no explanation even why they could not do it till today, the contempt has already been proven. But despite that, Lordship is pleased enough to say that even today you do it, first the contempt, come up, clean with, clean hand before this court. Therefore, Lordship has given some more time to them. On that day, let they be there so that to ensure that they will hand over the entire things before this honorable court so that the Lordship can close this petition on that. That's my response.
I can also submit on behalf of them.
If the appointment letters for this court to the standing council,
Yes, Lord.
why their presence is required.
But then no question. But going by the conduct, the whole.
Definitely they will wait.
Let us
Because
ensure.
they have appeared before this.
We hope and trust that.
Yes, yes.
But that isn't belied till today. That's my.
Let us say.
Yes. Kindly, Lordship, kindly see, whenever the case comes, someone else as government advocate will come one day. Next day, another will come. Next day, another will come.
That is because of the large number of cases, so far as education defense concerned. It is not the case. It is not the case that we are not complied with any cases till that Lordship. We have complied so many cases.
Let them show. I'll be happy to.
It is not the only one case, Lordship, we are not complied. This is not a sub. I am totally object to this, Lordship.
Let us wait. All right.
Yes.
Lordship had dispensed with their personal affairs on that day.
On that day, yes.
On that
This is not the only case.
What is the
yes,
appointment letter?
yes, yes, yes. Oblige. Deeply.
Yes, because it is,
Yes.
It's a war. So, yes, I have already stated 341 numbers of contempt cases are pending. All are relating to elementary education, secondary and higher education department. Credibility of your department is clouded by this inaction of the department. So how to go about this?
My lord, I personally review all these contempt cases. Many cases are not related to exclusively the department.
Yes.
So many cases are related to inter-department. When things come inter-department, department also sometimes we depend upon the views, concurrent.
You say one of the case relating to elementary education department is pending in the year 2014.
Yes, ma'am.
So already 10 years elapsed. The order of the court is not complied. So I am furnishing a list of these cases to you. They think about how can it can be resolved.
Yes, sure. In fact, my lord, we are having almost monthly review of all the court, not only the contempt cases, all the court cases. So if when you get the list, then we can have the second review.
Bless you, Lord.
I apologize for not being present when the matter was called up in the first.
But did
I
you
got
receive the notice?
yes. I got confused, my lord. I thought that this matter has been listed as item number 9. I was waiting outside, my lord. I've spoken with the authorities regarding
The question is why the
GPF amount has not been paid.
Yes,
my lord.
yes.
I've spoken with the authorities. My telephonic instruction is that this document, which is at page, not page 12, which is at page 18, my lord, the form which is alleged to have been forwarded to the office of the AG, actually it has not been forwarded, my lord. It has not been received by the office of the AG. Otherwise, they will not keep it pending, my lord. In fact, it says that it is routed through the office of the headmistress, but nothing. In fact, the headmistress also cannot forward it, my lord. The DEO, the District Elementary Education Officer, who will forward it to the office of the Accountant General. So, my instruction, telephonic instruction from the department, today's instruction, my lord, this form, my lord, proposal has not been received by the office of the Accountant General till date. So until and unless they get the proposal, my lord, question of payment doesn't arise. Anyway, they will not make the payment. They will authorize the payment. And the page 12 document.
Sir Roman, why this letter was not routed to the district elementary
Yes, my lord, no, but my lord, page 12, their letter, my lord. Can you see? PF account number, AC number is also written.
This is something different. This is regarding withdrawal of amount.
Let them, my lord, verify. Let them, my lord, let them, this letter may be verified, my lord. And after vacancy, if I am entitled, my lord, let them pay, my lord.
No, the problem is that this letter has to be routed for the corporation.
Probably he has not understood the contents of this letter, my lord. The Lordship will kindly see the synopsis, the first page of the my lord, petition.
18, my lord.
The petitioner retired on 31/12/2017, and this document is dated that means issued in April 2016, prior to retirement, my lord. This is regarding withdrawal of GPF amount. Probably at that time he had withdrawn certain amount from the PF account, my lord. This is not the proposal. If Lordship peruses, my lord, withdrawals at the bottom of the document, Lordship will say 54,000 something rupees. Closing balance is 1,64,000. This is not a proposal. This is a withdrawal statement, and that too issued prior to retirement, because the retirement date is 31/12/17, and this is dated April 2016. How can this be the GPF withdrawal proposal, my lord? It is probably a statement, my lord.
So this letter has to be routed to
the office of the DEO, District Elementary Education Officer. Probably he has done his job by submitting the application before the headmistress. The headmistress in turn has to forward it to the DEO, and the DEO will forward it to AG. That is my instruction.
whether this was forwarded by the headmaster.
Well, I don't know. They have annexed it. It says to the Accountant General through the headmistress, but the office of the Accountant General has not received it till date, my lord. And my instruction is the headmistress also cannot forward it directly. It has to be routed through the office of the DEO, District Elementary Education Officer.
Anybody from district elementary education?
Secondary. So the moment it comes to the office of the AG, within 10 days, we can authorize the payment, my lord. Page 12 statement shows that as of April 2016, the closing balance was 1,64,870. So, as on the date of retirement, probably it would be more than this amount. Probably, my lord, subject to correct.
Anybody for elementary education?
You can do. You can. He is there.
Mr. Romano, when this letter was received by the headmaster or headmaster?
Page 18. Oh, 24/12/24, my lord.
12/2024, my lord.
Bottom.
What happened thereafter? Whether she has forwarded it to the Accountant General office?
My lord, I inquired, but my lord, they say that this amount is pending, my lord, as per my instruction.
No. Whether they have forwarded this letter or not?
That I do not know, my lord.
Who will know?
Ask my lord.
It's a DEO Accountant General.
Do you obtain instruction? What is secondary education?
Three. আমি দিলে one.
Have you seen the another
Form B.
or Form B and page number 18? Can you enter from the headmaster to the principal?
Headmaster, your lordship, headmaster and principal, we are not appearing on behalf of them, your lordship.
You enter from the office of the inspector already.
Okay. He was lordship, I think take queries from the inspector of
Okay.
People as Rahman, man. People as Rahman.
Content.
5. 5. Events, take a look at the address. Declared on 31 or cases. You do not receive the his pensionary benefit. Can department take the and the order being passed by this court on 25/9/2019, the petitioner has received some of the pensionary benefits, but sum of rupees 1,64,870 rupees, the provident fund, general provident fund amount has not yet been released. And the petitioner has filed one application in Form B addressing the Accountant General Assam to the Headmaster from Administrative People of Morbag Kalag cases on 24/12/2024. But Mr. Roman submits that he is not aware of whether the claim forwarded to the AG, the Accountant General Assam or not. That way of the matter, it is provided that does are extending counsel products
I'm appearing for 3 and 5.
by shall obtain necessary facts of the office of the inspector of school about the status of Form P. The application filed by the petitioner on 24/12/2020 and appraised this court on next Monday. It is further clarified that tendency of this petition will not be a bar for responsibility.
All right.
Keep you.
Please, Your Lordship. There are two petitioners before Your Lordship.
Finding Timothy.
This case is covered by the Lordship, which I am referring to regarding the challenge of I am dated 18/9/2024 of the compassionate appointment. The government of personnel department abolished the compassionate appointment in the state of Assam. Annexure 5 page 30. Lord. Now, Lordship, I am referring a notice
So your case was
recommended by the
DLC.
DLC already recommended page 23.
Serial number?
Lordship. Page 23, serial number 1, Lordship. Petitioner number 1, page 25, serial number 8, petitioner number 2, Saurabh Pal. Page 25, serial number 8, Saurabh Pal, petition number 2, Lord.
Serial number?
8. 8. Now, Lordship, their application will be placed before the SLC, but the SLC on 30th
What is
August.
the order of this court?
Lordship, order of this court regarding their case, regarding their petitioner's case earlier.
Yes, you were mentioning that they
Yes,
have
Lord.
for petition earlier.
Yes, Lordship, in page 13, this is the writ petition of the petitioner number 1, Lord.
Page number?
Page number 13, annexure 1, Lord. This honorable court remanded back to the DLC for fresh place of his application. Accordingly, they have considered Lordship and forwarded to the SL. And annexure to page 16, this is the writ petition order of this honorable court in favor of the petitioner number 2, Lord. Pursuant to this order, these two orders, Lordship, their name has been placed before the DLC, and DLC by minute dated 30/11/2023, their name has been recommended to the for consideration for compassionate appointment before the SLC. Lord.
Was the order?
Yes. Elementary.
Anybody for state of Assam? Ready for the court. State level scrutiny committee.
Compassion officer.
For expert number 3 and 4, Lord. There is a two numbers of 3, Lordship. 3 and 3. 3 and 3. There is a
4 DLC.
correct. The numbering 1, 2, 3, 3. 4.
So the district level committee has submitted their name. Now, let us say
Yes, Lordship. But
Obliging.
May I please?
Yes,
I have
you have
filed
filed
the,
your affidavit.
yes, I have filed the reply, my lord. I
You
take,
have applied in a general category.
my lord, in the NEET, I was in general category, my lord. My lord, I take the lordship to page number 46 of the 64 of the affidavit, my lord. Because
on the other day, direction was of the so how many candidates are there? So could not file their application in time.
My lord, I have obtained the instruction that, my lord, around 10-12 candidates approached, my lord, approached the authorities after the result, praying for change of their category, but that has not been entertained, my lord. Around 10-12 candidates approached, my lord.
Yeah, if they are otherwise eligible, why they could not be allowed to change the
Because, my lord, after declaration of...
process is not yet completed.
No, my lord, admissions not completed.
Yeah.
But the process has started. The process has started on the basis of the merit list, which has been published and declared. And on the basis of that, first round of counseling started, first round of admission has been done.
Okay. Their cases could not be considered in the round of counseling.
Yes, my lord.
Second or third round
No,
of
it cannot be
counseling,
considered now.
consider their case.
Now it cannot be considered because we have to go back to zero, my lord. We have to go
Why?
back to the...
Why?
Because, my lord, now suppose, my lord, the petitioner or other candidates are allowed. In that case, some other candidates have to leave their seats, my lord.
No.
No, in the reserve category, because...
Admission process is yet to be completed.
No, completed, but they have... their names has been took place in the merit list. And, my lord, I would like to refer to some of the judgments where it has been specifically held that after declaration of result, category change is not allowed, my lord. Your lordship may peruse it, my lord. It is a judgment passed by the Division Bench of Rajasthan High Court and Division Bench of Punjab High Court, my lord. Punjab and Haryana High Court. In these two judgments, it has been specifically held after publication of the result, the category cannot be changed.
Which paragraph is relevant here?
My lord, first, here the key points are there, my lord. And, my lord, first judgment, my lord, your lordship is going to the judgment of Punjab or Rajasthan, my lord. Punjab, my lord. So, in paragraph 12, my lord, your lordship will find in the result the petition succeeds. Respondent number 2, Government Medical College, Chandigarh is directed to cancel the admission given to respondent number 3 in the reserve category. Because the respondent number 3 reserve category was allowed after declaration of result. Respondent number 3 applied as a general candidate. Then her candidature was changed to reserve category. So that was directed to cancel, my lord. Because the principle is that after declaration of result, the category cannot be changed, my lord. In the other judgment also, my lord, the judgment passed by the Rajasthan High Court, my lord. Division bench of the Rajasthan High Court, my lord. Here also it has been held that, my lord, candidate cannot change his category after the declaration of the result.
Where? Paragraph number.
My lord, the issues first is, my lord, issues whether the respondent number was entitled to change his category from general to EWS. Because initially he applied as a general candidate. Subsequently, he wanted to change his category from general to EWS.
Which paragraph this was dealt with?
Yes, my lord, I am pointing out. Paragraph 9, my lord. Respondent number 1 applied for
paragraph 9, thus in the present case, respondent number 1 had not challenged the action of the appellant in not making reservation for EWS before filling the form 2020. Importantly, my lord, respondent number 1 applied for admission in general category and failed to get the seat as he was lower in merit. Respondent number 1 approached this court after he found that his name did not figure in the list of candidates who had been granted admission in the course in general category. Hence, it was not open for respondent number 1 to have invoked jurisdiction of this court after he had taken the entrance test and had failed to make it in the merit list. Respondent number 1 cannot derive any benefit from the email so, wherein it was communicated to him that EWS quota seats were available in round 1 of PG counseling. Since in the application form itself there was no column showing reservation of seats for EWS quota, the mentioning of the fact that EWS quota seats were available in round 1 of PG counseling was without any basis. Realizing the mistake, appellant had sent another email the record copy placed on to respondent number 1 clarifying that EWS quota seats were not available in round 1 of PG counseling. It was also clarified that the security would be responded. In the facts and circumstances of the case, relief sought by the respondent number 1 could not be granted to him. The argument raised by the learned counsel for respondent number 1 that as per office memorandum dated scheme for implementing the reservation for EWS was to be displayed on the website is concerned, the same is rendered economic for the purpose of writ petition. Hence, we are not going into the controversy with regard to implementation of the office memorandum dated In view of the facts and circumstances of the present case, we are of the considered opinion that the learned single judge fell in error in allowing the writ petition filed by the respondent number 1. For respondent number 1, my lord, initially when they filed the writ petition, the honorable single judge allowed his petition, allowing him to change his category. But subsequently, division bench has rejected it, saying that, my lord, after declaration of results, the category cannot be allowed to be changed. And my lord, one more aspect I would like to point out before your lordship, my lord. In one case, I referred to this, my lord, the brochure, my lord. In this information bulletin also, it has been specifically stated that after making the application, my lord, it cannot be changed, my lord.
It cannot be changed, then how can you the notice?
My lord, because if the authority is kind enough to allow for certain period before publication of the result, if he challenges that, okay, that will also go, my lord. But the authority has some power or some right that for the benefit of the student, before publication of the result, my lord, they have allowed, my lord. Authorities was kind enough to give a chance to the candidates, my lord. If he challenges that, that will also go, my lord. Because on the basis of that, and for that purpose, the candidate who has been benefited from that notice, he has to be made a party. That has to be challenged, my lord. But otherwise, if your lordship peruses this information bulletin, my lord, lordship kindly come to page 43, my lord.
Yeah.
Page 43 starts with general instructions and submission of application for payment of fees, my lord. Then, my lord, page 44, my lord. 44, filling clause 7.2, filling up application form, my lord. So this is the procedure how the application form has to be filled up, my lord. Then 7.3 is the instruction for completing the application form. 7.3 continues. Then, my lord, in page 46, just below the clause 7.3.8, my lord, there is a note, my lord. Page 46, my lord. Your lordship has got it. 46, note clause 1, my lord. Request for change in any particulars in the online application shall not be entertained under any circumstances. So under any case, because while submitting the application form, they have to specifically select their category, my lord. Whether under ST, SC or PWD, they have to select, they have to submit the application, and after request for change in any particular in the online application shall not be entertained under any circumstances. So coupled with the decision by the division bench that after a publication of the result, the category cannot be changed. And it is not only in respect of medical admission case, in other examination also, we have found several cases that after declaration of the result, my lord, the category cannot be changed. He appeared in the test as a general category candidate. Accordingly, the results have been prepared. His name figured in the general category, my lord. And under the reserve category, the names of some other candidates have been figured out. So now there are around 10, 12 applications apart from the petitioner, my lord. So now if they are allowed, those have to be dislocated from their merit list, my lord. Their rights will also get affected, my lord. They have to be made a party to the proceeding. Because to accommodate the petitioner or the other candidate in the reserve category, my lord, some others, the candidates who have been already selected, they have to remove from the list, my lord, because it is limited. We cannot increase the seat, my lord. If there are 20 seats for this particular category, it will be 20. So to accommodate petitioner or other 10, 12 candidates, we have to remove another 10, 12 selected candidates from that list, my lord, who have got the position in the list, my lord, by complying with all the norms and all the procedures.
It's finalized, right?
Yes, my lord. On the basis of that list, the admission process, first round of admission process has completed. Second round, the counseling has started from 10th September, my lord. So
that list is yet to be prepared. Because
no,
counseling is yet to be started.
10th September, from 10th September, it has started, my lord. It is going on. That notification also I placed before your lordship, my lord. I can produce the notification also.
It is at page number 104 in my affidavit reply.
104 to Purana.
The second round of counseling is still going on.
Yes, my lord. It has started, so as per the notification, it has started from 10th of September, my lord. So counseling,
Why the case of the petitioner could not be considered at this?
because already merit list has been published prior to start of the counseling, my lord. And as per law, my lord, also, because I have referred to the division bench judgment, my lord, after declaration of result, the change of category is not permissible, my lord.
Right. But you have issued a notice inviting application for change of category.
Yes, my lord, we have issued the notice once. If your lordship held that is also illegal, that is a different aspect. But if we have issued the notice, notice once, my lord, giving some opportunity to the candidate, that should not be that should not be taken as a negative one, my lord, because we have.
While exercising,
And that is before publication of the result, my lord. That is the main issue, my lord. Publication of the result, preparation of the merit list, my lord. That was before preparation of the merit list, not after the merit list.
so according to you, under no circumstances, the case of the petitioner can be considered.
Yes, my lord.
Yes, sir.
My lord, with regard to my lord, judgments my learned friend referred, these are all post-admission, my lord. After admission, if complete seat is reserved and finally admission is done, thereafter no one can change the seat category. That is admitted fact. In our case, is a pre-admission stage. Number one. Number two, my lord, my learned friend has submitted on brochure at page number 43. Online change is not permissible. In online application, our application is accepted as OBC NCL category. These are my lord, submission. My lord, I take a lordship to page number 64 in my reply method. The rule says, my lord, application form. What is the application form, my lord? Is given the definition. Means the form at schedule 1 of these rules to be submitted, page 64, my lord, of the affidavit reply. Is the application form definition given, my lord? Means the form at schedule 1 of these rules to be submitted by the candidate at the time of counseling by filling it up as per the instructions along with all the relevant annexure certificate. Now the schedule 1 is at page number 72, my lord. This is the application form has been accepted through online. The relation
is paragraph number?
Paragraph number page 64, rule 2.3 definition, application form.
Yes.
Application form means the form at schedule 1 of these rules to be submitted by the candidate at the time of counseling by filling it up as per instructions along with the relevant annexure certificate. You will find page number 72 is the application form. This form is accepted only through online after the issuance of the notice for second counseling. The relationship between the candidate and the DME starts, my lord, at the time of submission of this application form, not prior to that. Therefore, and every counseling is an independent counseling, my lord. It is not connected with earlier one. It's an independent counseling. Because for every counseling, notice has to be floated. After notice, registration form, there is the schedule 1 form has to be submitted along with necessary documents as per the schedule given in the my lord, form itself. Annexure certificates are given, SC certificate, OBC certificate has to be submitted as per this statute, my lord. Then this relation starts at every counseling stage. It is not that the ones I submitted in the first round of counseling, I did not submit and I will go on competing. Not that like, not that, my lord. It is in every stage. Suppose third counseling takes place tomorrow after this counseling.
in that stage also one has to submit the application form as per this schedule, my lord, once afresh. It is not that this time I have submitted, I did not submit. This is not the questions, my lord. And so far as the seats were already filled up, we are not against them, my lord. The seats remaining vacant against those only. Those, even those have been appointed, we have no grievance, admitted, we have no grievance against them. After the each, as per the rule, my lord, the relationship starts at the time of submission of the application. The right accrues, and the rule also 5C specifically states, my lord, the you have to, my lord, submit everything through the registration form, and the verification will start, and certificates will be verified, my lord, at the time of counseling. Therefore, as per the statute, my lord, my applications ought to have been considered, because the online applications has already been accepted as per OBC NCL certificate.
But where is the explanation for failing to apply within that period, the stipulated period?
That is, my lord, I have stated this is an not unwanted administrative exercise they have carried out, my lord, by issuing this notice.
No. Your application, where you have explained it, for failing to apply within the stipulated date.
My lord, in application means what application, my lord?
In your it is a writ petition.
Or writ petition, my lord. That I have given application explanation, my lord, that I could not procure at the point of at that point of time. That's why I could not, my lord, submit.
Which paragraph you have stated?
I am giving it. It is given in, my lord, paragraph 3, my lord. Entire story I have written, my lord. And in the affidavit reply also, in paragraph 3, 4, 5, 6, my lord, I have given the submission. Paragraph 3. My lord, 3, 4, 5, 6, my lord. In this paragraph, I have given the submissions, my lord, in that aspect. And one judgment I found thought it, my lord, might be relevant, so I have also annexed. Wherein, my lord, in case of Odisha, what happened, my lord, in respect of PG course admission, my lord, second round of counseling, the candidate was not allowed to participate in the second round of counseling, as he could not, my lord, produce the college leaving certificate. And that honorable court, my lord, has ultimately allowed this, my lord, the candidate to be appointed, because it was not the requirement of the law at that point of time. In the instant case also, my lord, as per the statute, my lord, change of category is not a requirement to be done prior to that, my lord. It is to be done on the day of counseling, at the time of filing of the application. Application means application form, which as per Schedule 1.
I don't know. It's page number 143.
Page number 153, my lord.
43 or 50?
53, my lord. 153. Let me just 153, my lord. 153. The relevant paragraph I have just marked, my lord. Obliged. Obliged.
Yes, my lord. Yes, my lord.
Regarding the
Yes, my lord.
where top okay.
Yes, my lord.
You see as it
Amended.
amendment
Yes, my lord.
by
24.
2024.
Yes, my lord.
Now the board is not required to be completed by the head of the department.
No, that is not required. No.
But
For-
you have to follow the guideline.
Yes, my lord.
Of assessment.
Yes, my
Right?
lord.
Now, you're actually getting the report. Board. But whether you follow the guideline by the
2017 rules, that guideline was there that three heads of the departments of orthopedics.
Yeah.
Because, my lord, till that time, my lord, only the persons with locomotor disability was allowed. So that time that the requirement was that the board has to be constituted with three heads of the department of orthopedics. But that has been amended and subsequently other disabilities have also been allowed.
Yes.
So that's why one specialist from each of the department, my lord. But specifically because in the information bulletin also I have pointed out, my lord, specifically it has not been mentioned anywhere that how the board has to be constituted. Only the disability assessment board that has been referred to in the information bulletin. And in that guideline, no, that has complete that schedule 3 has been completely substituted in 2024.
24 rule
Yes, my lord.
is provided that the assessment has been done as per the 16th rule.
That is persons with disability rules, my lord.
Yes.
Yes, my lord. So that as per the act, my lord, it requires that specialists from each of the departments should be there in the board. Because as per the rules,
There, I am not on the board. But how to assess? Provided that
no, assess how to assess, my lord. That applies there. That is by the Ministry of that Social Empowerment. That ministry, my lord, they have a specific guideline for how that has to be assessed, my lord, and that is followed by every that medical board, my lord, everywhere, my lord. There is specific guidelines, my lord, in terms of the rules of the Act of Persons with Disability Act, my lord. Not our department.
the report you have submitted.
Yes, my lord. Yes, my lord.
Is silent on that.
No, that is only assessment. The records will say that, my lord, how it has been assessed. Because we have produced only the report, my lord. Normally, whenever a certificate is issued to a person, only the certificate is issued. But how it has been assessed, it is not make known to him, my lord. So if your lordship desires, then I can obtain the entire records from the department, then I can produce. But how it has been assessed in the report, that will not be revealed, my lord. Because it is a report. That is how the percentage of disability that has been assessed. But it doesn't...
No, for a indication that guidelines are followed while making assessment.
No, my lord, the rule itself, information bulletin itself says how it has to be assessed, my lord. Information bulletin says, my lord, how it has to be assessed.
Take the record.
Yes, my lord, I can produce. If your lordship direct me, then I can produce the record along with how it has been assessed, my lord. So, my lord, because sometimes, my lord, what happens on earlier occasion also, some of the candidates have challenged that the calculation, the assessment. So, on those occasions also, we have produced the records, my lord.
Can you produce the record tomorrow? We'll list the matter.
Tomorrow, my lord, now it will not be possible, I think, my lord. Day after tomorrow.
Day after.
Yes, my lord.
You try to in a second.
Day after tomorrow will be, because, my lord, unless and until I communicate them in writing, my lord, they will not send, my lord. It is not the office. Because, my lord,
okay.
By the time I make a written communication, their office will be closed, my lord, now.
Okay. Then day after tomorrow.
Yes, my lord.
Okay. Produce the record of.
Yes, my lord.
Obliged.
Obliged, my lord.
May it please your lordship. May it please your lordship. It's a matter pertains to non-payment of subsistence allowance and also challenge the illegal substance suspension order, your lordship. And your lordship kindly move to your lordship's order dated 19/8/2025, your lordship. They have not complied the order.
May it be pleases your lordship. Your lordship, in this matter, your lordship, U Sharma is appearing on the last occasion and he is out of station. So kindly, I pray for your lordship a one-day accommodation, your lordship. Some other day may be fixed, your lordship, on the next week. Any date may be given, your lordship, before vacation.
Mr. Rampi is present in the court today.
U Sharma. He is out of station.
In always the name of Rampi was reflected.
She is also out of station, your lordship. She is not present today.
No, the direction was to obtain instruction and to make payment of the subsistence allowance as per direction of this court. Why the same is not been complied?
Pertaining to that, your lordship, next date, any date may be given, your lordship. In between, your lordship will convey it, your lordship, to you, Sharma, your lordship.
No, the order is that in the event of failing to make payment of the subsistence allowance, the court will consider personal appearance of estimate number.
Your lordship, Friday, your lordship, Friday, a date may be given, your lordship, of Friday, your lordship.
No, Friday. Friday it will be inconvenient for me. Friday will be inconvenient before that.
Then any date may be given.
25 or 26, your lordship.
Yes, your lordship.
That will be convenient for me.
Yes.
Or Buddha or litigation. Either secretary part and thus submits that the matter was assigned but due to difficult court when
25th.
before that day,
Twenty 23rd Tuesday, no?
Hearing
Your Lordship.
the 23rd, Your Lordship.
when
19th also will be convenient for me. It will be better. 19th, Your Lordship.
further provided that
19 Friday আপনার কারণে দিব
No, মই 26 টো ভাবিছিলো।
payment of subsistence allowance to the pensioner. The direction for payment of subsistence allowance to the pensioner shall be complied. Otherwise, the direction by order dated 9/8/2025 shall be carried out.
deeply obliged.
Well, in this matter, well, on last occasion, I have taken time. Well, I need some more time because due to some personal difficulties myself, well, I could not prepare. By Wednesday, I will file it. Well.
Otherwise, my lord, it is admitted fact.
This matter may come up on 23rd, my lord.
Issue involved, my lord, senior and junior. I am senior most officer, but junior one already been appointed as provincialized. And therefore, the court was pleased to stay their salary. And now it is admitted fact, so far my contention is concerned, paragraph 5, that has been admitted, yes, they say that true, that they are junior. Junior, how can be entitled to get vigilance? And so far the act is concerned, my lord, the school, my lord, ME school, ME madrasa, now so far this act or lordship.
Mr. Mia, if the affidavit is not available before the court,
But the number of time we have taken. It is
I
a
have
matter of
admitted I have some
2021.
difficulties, so I
It's a
could not
matter of
prepare, my lord.
2021.
okay, you file it
By Wednesday, I'll file it, man. Wednesday morning, my lord, I'll file it.
okay. Take it up
On 23rd,
PM
my
on Wednesday.
on 23rd, my lord.
Okay, Lord.
That's it.
Witness.
That is
I am for restaurant number 567.
your name, please.
EDB.
For order pay. You will file the pay by morning of Wednesday. And you have provided that on Wednesday.
Lordship.
Nice.
Candidate for the
Okay, I'm appearing for the SSA.
Please, Your Lordship. With regard to the pension matter, Lordship, there was a direction from this Honorable Court. Submit instruction with regard to the leave encashment correction along with the pension correction, Lordship. Your Lordship, it is under process, Your Lordship. Already file has been forwarded, Your Lordship.
Madam, you have appeared before the
Lordship,
inspector
Lordship,
Mm.
Lordship.
8th of September.
Lordship, pursuant to the last order, the petitioner has appeared, Lord. Pursuant to last order of this
For
honor.
verification of Your Lordship, several documents, that is copy of service book and earlier sanction order copy, leave encashment, and that's Your Lordship for period of leave encashment benefit. So Your Lordship, as per Your Lordship last order dated by this honorable court, the order has complied. So Your Lordship, verification has already been done, Your Lordship, and thereafter Your Lordship, the file has forwarded and it was under process.
So when the
A time period may be given, Your Lordship. A time frame may be given, Your Lordship.
Lordship may fix a date. In the meantime, let them release the amount.
Disposed of the matter, Your Lordship, by framing the date, Your Lordship. Time period.
or data look right?
Data local law.
Garnet. Or the uh, right. Order of this court dated 19/8/2025. The petitioner that appeared for the effect of agency of income statement and thereafter the inspector did the provision or disciplinary and benefit of the petitioner along with press brief account for allowance certificate and the xerox copy of certificate book and earlier sanction order of agency. The director of the accreditation process and as some that of direct complete the entire timeline out of September. Uh, with the amount which the by the Arabic the uh, the part that is the after the and the meantime the response for this delivered with the amount which the petitioner and said the written instruction received by the and produced for the market and he will be checked with the record. You direct them to release the release the amount.
Much obliged, sir.
Deeply obliged.
The matter pattern, my lord, non-sanction of special family pension. And my petitioner's husband was killed by extremist, my lord, in the year 2004, my lord, while serving as a state teacher, my lord. My lord, although my lord, regular pension was sanctioned, my lord, but the special family pension was not sanctioned, my lord. Subsequently, my lord, he had approached the this honorable court, my lord. The court has decided the issue, my lord. The lordship will find the order at page 21, my lord. And the operative portion will find at page 31, my lord.
Order dated
Order dated, my lord, 13/8/2018, my lord. It starts from 21, my lord, and operative portion is at page 31, my lord.
It
starts from 21, my lord, and operative portion at page 31, my lord.
the Deputy.
Yes, Your Lordship. Lordship, in this matter, way back in 17 to 24, we have the Directorate of Pension has requested the Inspector of Schools, KDC Amingao, for submission of the duplicate oblique reconstructed copy book in respect of the late Jitendra Nath Deswal. So that has not been received. If it is received, immediately the Directorate told corresponded to me that they will do the needful, Your Lordship. So I'm furnishing a copy of this communication that has been received by me to my learned friend so that they can do the needful and update this.
What is the instruction?
Instruction is that, Your Lordship,
Original service from. Yeah, we say go to. Yes, madam.
Your Lordship, communication later I will take from the council, Your Lordship, and will Your Lordship forward it to the department, Your Lordship, to do the needful, Your Lordship.
No, you have to obtain instruction from the inspector of school.
Yes, Your Lordship. I'll forward that letter, Your Lordship, that communication letter. No. Good point.
Part minister.
Yes,
Yes, of garden. Mr. Deputy for respondent number.
I'm for respondent number 4.
Respondent number 4. Ms. P does for respondent number.
I'm appearing for respondent.
number 5.
Here, elementary is showing, Your Lordship.
8.
I'm only for 7 and 8, Your Lordship, DSC and Inspector of School. Here, elementary is showing, Your Lordship, and pension.
Subsequently,
120.
Yes, sir, that is amended, my lord. Well, my lord, the inspector general director secondary education was very implemented, my lord, and notice was duly served, my lord. Or can proceed.
And Ms. Pokon for respondent number
123, my lord.
123.
12, yes, my lord, 123.
123.
Acceptable.
In the course of deliberation, Mr. Devi has produced one letter issued by the Director of Pension, written by the Director of Pension, dated 12/9/2024. I got. Stating that due to non-availability of the original service book and other related documents, the Directorate of Pension could not process the file and has requested the inspector of school, KDC Amingaon, for submission of duplicate reconstructed service book in respect of the executive of Das, along with taking necessary action towards granting special family pension. Ms. Dina Das, the petitioner here. But no reply has been received by the directorate team.
Family pension.
Sir Devi further submits that he has furnished a copy of the letter dated 12/9/2024 to Ms. Peters concerning toxic, so as to enable her to take up the matter with the inspector of school, KDC Amikon. Accordingly, it is provided that Ms. Das concerning toxic to the respondent number 7 and 8 shall obtain necessary instruction and apprise this court on next return that is the matter of 13 or 14. 15.
Deeply obliged.
Obliged,
May I please? My lord, the petitioners are the selected candidates for the post of grade 4, my lord, and they have applied pursuant to the advertisement issued in the year 2005. And this is a fifth round of litigation, my lord. Already pleadings are complete. I take your lordship to page number 34. This is the notice issued by the director elementary, my lord.
Who is appearing for elementary education?
Elementary, they have filed their affidavit, we have filed the reply, my lord.
No, who is appearing today?
We have got some urgency because, my lord, the posts are going to be filled up by 10th of October. So some urgency is on our part. Therefore, I made the mention.
Okay.
My lord, matter will be taken after some time, my lord. My lord, in this matter, my lord, NJ Continuer will apprise this.
Is the present in the court?
Yes, my lord. So kindly after some time, he is on lakes, my lord.
Well,
May I please, your lordship? Here in this case, lordship, the petitioner is the assistant headmaster of the school concerned, lordship, of the Sadin Bazar High School, lordship. Lordship, and he has been, lordship, serving in the graduate scale of pair, lordship, since 1991, lordship. And after the death of lordship, earlier headmaster, lordship, he was allowed to act as an in-charge headmaster of the concerned school. Subsequently, Lordship, the respondent number 4 preferred a writ petition before dishonorable court, Lordship. And dishonorable court, Lordship, initially passed an interim order, and thereafter, Lordship, by final order, Lordship, final judgment and order dated, Lordship, 12/10/2023, page 45, Lordship, disposed of the said writ petition, Lordship, setting aside the appointment of the petitioner as an in-charge headmaster of the said school and remanding the matter back to the director, Lordship, to consider the same, Lordship. Your Lordship may kindly see page 48 is the operating part of the judgment, earlier judgment, Lordship.
Yes.
Page 48, paragraph 11, Lordship. Only that judgment, Lordship, my appointment was set aside, Lordship, only as I have not the B.Ed degree, Lordship. So, but basically, Lordship, I was the, still now, Lordship, I am the assistant headmaster of the said school. So, after demise of the earlier headmaster, Lordship, being the assistant headmaster, I was acted as in-charge headmaster of the school, Lordship. This honorable court, may read the paragraph 11, Lordship.
Yes.
Paragraph 11. Accordingly, the impugned order dated 26/2/2021 is set aside. The matter is remanded back to the Director of Secondary Education to pass a fresh order as to who should be the in-charge headmaster of the Shadin Bazar High School. In doing so, the Director is also take note that under the law as laid down by this court in the case of so wherein it had been provided that to be an in-charge headmaster, the incumbent concerned should have the necessary qualification of a regular headmaster, and further that under Rule 14 of the Assam Secondary Provincialization Service Rules 2018, the required qualification to be a headmaster also includes a degree of B.Ed, meaning thereby that an incumbent who would not have a B.Ed degree may not be entitled for being promoted either as the headmaster or being allowed to be the in-charge headmaster. The director to take note all the relevant applicable for appointment of headmaster. So ultimately, my appointment as an in-charge headmaster was cancelled. But now, Lordship, what was happened, Lordship? I have not the B.Ed degree, Lordship. But the respondent number 4 also did not complete the 15 years of Lordship requisite qualification of graduate, because his service was provincialized only in the year 2013. So since 2013, Lordship, he has been receiving the graduate scale of pay, Lordship. So he was also not eligible in terms of, because the two requirement is required, Lordship, B.Ed degree along with 15 years experience. But 15 years experience, Lordship, as an graduate teacher, Lordship, that was not fulfilled by the respondent number 4, Lordship. So, and along with that, Lordship, the respondent number 4 also, Lordship, acquiring his B.Ed degree without permission from the authorities, Lordship. Your Lordship, kindly turn to page 49. The information which was provided by the inspector of schools, Lordship, to the petitioner. That, sir, with reference to your letter mentioned above, seeking information whether Sri Om Prakash Chaturvedi, science teacher of Shadin Bazar High School, has obtained any NOC from this office while pursuing B.Ed degree through ODI mode during his regular service period in the year 2013 to 2015. On checking the relevant file in this regard available to this office, I found that no NOC was given from this office for pursuing B.Ed degree. Further, he had not applied for the same from this office. This is the information provided by the inspector of schools, Lordship. Then, Lordship, in next page, page 51, Lordship. Page 51, which is the information provided by the director, Lordship, from the office of the Director Secondary Education, Lordship. Subject is regarding no objection certificate for B.Ed degree of Sri Om Prakash Chaturvedi, science teacher, Shadin Bazar High School. So here, sir, with reference to the subject cited above, I am directed to enclose herewith a copy of prior petition of Assistant Headmaster of Shadin Bazar High School, and request you to take necessary action as the Inspector of Schools is the appointing authority of the assistant teacher as per rule. The appointing authority issues
the no objection certificate. Further, it is also stated that this directorate has not issued any kind of NOC for B.Ed degree of Om Prakash Chaturvedi, science teacher, Shadin Bazar High School, Kacha. So, Lordship, he acquired, although Lordship, in the year 2013, Lordship, his school was provincialized. So, and he acquired the B.Ed degree in the year 2014, Lordship. So, as per rules, Lordship, he ought to take permission, NOC from the authority, Lordship. But that was not taken. And accordingly, Lordship,
What is your prayer in this case?
Lordship, my prayer is to set aside the appointment of the respondent number 4 as an in-charge headmaster.
Then who will be the headmaster? In-charge headmaster.
Lordship, because Lordship, on the facts of the case, Lordship, there are no one eligible.
Then,
So naturally, Lordship, the inspector of schools may be handed over, Lordship.
how you were aggrieved?
Sorry, Lordship.
How you were aggrieved?
Lordship, I am aggrieved because, Lordship, I am the assistant headmaster of the school. Admittedly, I have no B.Ed degree, but because I am not the assistant teacher, Lordship, I am the assistant headmaster of the school, Lordship. So naturally, in absence of the Lordship headmaster concerned, I require to Lordship hold the charge of the headmaster, being the assistant headmaster. Otherwise, Lordship, the post of assistant headmaster would not required to be Lordship given in the schools, Lordship. And besides, Lordship, he is not at all eligible because, Lordship, he does not have the requisite Lordship experience of 15 years in the graduate scale of failure. Along with that, he had not obtained his B.Ed degree without, he obtained his B.Ed degree without permission of the authority. That is my case.
May I submit, my lord? My lord, I take a lordship to education manual page number 35, where the rule is given, my lord. Rule 14 of the 2018 rule is the rule which provides the eligibility to rule, page number 35 of the education manual, my lord.
Yes.
For regular promotion to the, my lord, post of headmaster, the post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from the candidates amongst the graduate teachers as per district-wise seniority list on the recommendation of the district selection committee constituted under Rule 16.2. The selection of headmaster and superintendent shall be based upon the seniority and satisfactory annual confidential report for last 3 consecutive years as per the procedure provided under Sub-Rule 3. Provided that the seniority of the graduate teacher shall be determined from the date of receiving graduate scale of pay by the respective assistant teacher. The eligibility for the post of headmaster and superintendent in high school, high madrasa, as the case may be, shall be as follows. He must be BA, BSc, BCom with B.Ed, BT, B.Ed degree from any recognized university. In respect of Hindi teacher having degree qualification in the Hindi Parangat and Nishantar shall be considered instead of BT, B.Ed. He must have at least 10 years of teaching experience as graduate teacher. It is not the 15 years of teaching experience, my lord. It is the 10 years of teaching experience in respect of headmaster of the high school. And I was getting the graduate scale of pay with effect from 1/1/2013. And I completed 10 years by 23. And the order which is put to challenge is of my lord 24/6/2024. That too passed after my lord passing of the judgment by this honorable court. And in that case, he was the party contested, my lord.
Where is that order?
My lord, it is given in the page 52 of the writ petition. He was a party in the earlier writ petition. He contested the case, my lord. And thereafter, he is challenging this order, my lord. And that is the compliance order of the earlier round of litigation. He has not preferred any appeal against that order. No review, no appeal.
Requisite experience is 10 years.
Lordship?
Requisite experience for holding the post of
Yes, 10 years teaching experience.
Pardon?
10 years of teaching experience and B.Ed degree and graduation. One must have, and he should be getting the graduate scale of pay. That is the thing. To become the headmaster. And
Yes,
requirement of NOC, your lordship has settled the law, my lord, in the judgment of Madhav Chandra Kolita in WBC number 3929/2024, order dated 27/2/2025. And he has passed from the IGNOU, my lord, without hampering his regular duties.
yes, Mr. Barboya. If the requirement experience is 10 years, then the petitioner possesses the same qualification.
Yes, Lordship. At the time of passing of the impugned order, Lordship, he admittedly he completed, Lordship. But that part, Lordship, because Lordship, without permission from the authorities, because the inspector of schools as well as director, Lordship, they have stated that he did not take any NOC from the authorities. So if that he would be allowed, Lordship, because admittedly, because that was assistant teacher regarding the promotion of the assistant teacher to the post of headmaster concerned, Lord. But here, Lordship, I am the assistant headmaster. So when an assistant headmaster is there in the school, Lordship, then in charge headmaster, Lordship, regular headmaster they may appoint, Lordship. But in chargeship of the school, Lordship, that might not become here, Lordship. Because admittedly, I holding the post of assistant headmaster since 2017, Lord. When my earlier school was amalgamated with the high school.
If you do not possess the requisite qualification, then how can you challenge it?
Yes, that is the law settled by this.
Without permission, Lordship, one Lordship taken the degrees, Lordship, during his regular appointment, Lordship, although that may be a distance move, Lord.
Madhav Chandra Kolita, my lord, it is in the WPC number 3929/2024, order dated 27/2/2025.
Is it part of the record?
It is not the part of the record because it's past affidavit is filed earlier, long back, my lord.
Yes, madam, what is your submission?
Your Lordship, we have filed our affidavit, Your Lordship. From our affidavit in opposition, page 72, paragraph 4, which continues from 71, but I would like to read the relevant portion, Your Lordship, that is 72.
Briefly tell me what is your step.
Your Lordship, first of all, Your Lordship, he does not fulfill the criteria. And as laid in the Act, Your Lordship, we elaborately stated in our paragraph 6, Your Lordship, that 10.4, Your Lordship, paragraph 6, page 74.4. Rule 14.2 2B provides that to be a headmaster of high school, he must have at least 10 years teaching experience as graduate teacher. Continuation to that, in case of amalgamated high school with ME, MV, the assistant headmaster is eligible for headmaster on condition that he must have at least 15 years of teaching experience as graduate teacher, including the period of service in the erstwhile ME, MV school. And thereafter, Your Lordship, in paragraph 7, that is page 75 itself, Your Lordship, we have categorically stated that the answering deponent further begs to state that after perusal of records, it is found that the respondent number 4, that is Sri Om Prakash Chaturvedi, having BSc degree and obtained BA degree from Indira Gandhi National Open School, that is IGNOU, in the year 2012, when the school was in venture stage. And he was only qualified teacher having BA degree of the school. However, at the relevant point of time, he did not fulfill the criteria of 10 years of teaching experience as graduate teacher, as he had received the graduate scale payoff with effects from 1/1/2013. On the other hand, the petitioner, that is Shri Fakrul Islam Mozumdar, BA designated assistant headmaster, received the graduate scale pay 1911-1991 onwards, but he has no BA degree. In compliance with the order, Your Lordship, that is dated on 12/10/2023, passed in writ petition 2326/2021, filed by respondent number 4, that is Om Prakash Chaturvedi, and after thorough examination of the records, the respondent number 4 was temporarily allowed to act as headmaster in charge of Swadhin Bazar High School, District Kasar, wide order dated so and so, dated 6/6/2024, which is annexed in the annexure 15 in the writ petition, issued by the Office of the DSC Education. So, Your Lordship, after verify all the documents, Your Lordship, he was temporarily charged, Your Lordship, given charge. And Your Lordship, moreover, Your Lordship, if the rule says, if the act says that he does not fulfill the criteria, the petitioner does not able to fulfill the criteria.
My lord, your lordship may kindly turn to proviso to lordship rule 14, lord. Proviso, wherein it is stated that provided further that in case of amalgamated high school, where ME MB school has been amalgamated, the assistant headmaster is eligible for selection as headmaster, subject to the condition that the incumbent should have at least 15 years teaching experience as graduate teacher, including the period of service in the erstwhile ME MB school. So, lordship, here, lordship, in the proviso, lordship, that 15 years service was given, lordship, but lordship, that rule 14 of 2018 rules, lordship.
Page number?
Lordship, page number
36.
36. My lord, 36, lordship. Actually, I am having the PDF copy, lordship.
But as per 2B, 14 2B, he possesses the 10 years teaching experience.
10 years teaching experience for graduate teacher assistant, that meaning there be assistant teacher, lord. But I am the assistant headmaster, lord. So for assistant headmaster, lordship, that perhaps, lordship, the legislature, lordship, that B.Ed degree is not required because, lordship, I am the assistant headmaster, and that proviso giving that 15 years experience is required. So naturally, as a graduate teacher, lordship.
Whether the school was an amalgamated school.
Amalgamated school, lordship. So my school is amalgamated in the year 2017, lordship, and I was the assistant headmaster in the erstwhile ME school. Subsequently, in the amalgamated school, lordship, I was given, lordship, as an assistant headmaster, lord. And the inspector of schools also sent, lordship, the proposal as I was the assistant headmaster, lordship, of the school. So, lordship, because that differentiation was given, lordship, 10 years experience for graduate teacher and 15 years for assistant headmaster. So here, lordship, the B.Ed degree was not given because, lordship, I am the assistant headmaster. So as per that proviso, lordship, I am very much eligible, lordship, to hold the charge.
May I please? My lord, for the purpose of headmaster promotion, my lord, the assistant headmaster includes also the graduate teacher. Graduate teacher also includes the assistant headmaster. My lord. As per page number 23, my lord, class and cadet is given.
Page number?
Page number 23.
Yes.
There is no classification between the assistant teacher and the assistant headmaster, my lord. It includes cadets of assistant headmaster, assistant superintendent, graduate teacher. They are in the same class. Therefore, my lord, the rule cannot be, this rule is not exclusive, my lord, it is inclusive. It has to be taken into consideration rule B, 14.2b, as well as 14.2a. And the proviso is only for those assistant teachers, my lord, or assistant headmaster coming from the ME schools. He has come from ME school to the high school, and I am in the high school itself. Therefore, in my case, only 10 years experience, and his case is 15 years experience. 15 years, not in case of mine, because I was in the high school itself. And he was, through amalgamation, he has come to my school. Therefore, in his case, 15 years teaching experience. But the qualification, there is no compromise, my lord. It has to be B.Ed and graduation. Therefore, the DSC Assam has given me.
So, Mr. Borgoya, what is your case now?
My lord,
What is your case? The 15 years teaching experience is applicable in your case only, not in the case of the respondent.
yes, lordship. But that proviso, lordship, because lordship, that proviso, because otherwise, lordship, because the 15 years experience is not required, because 15 years experience in the graduate scale of pay is required, lordship. So if lordship amalgamated school is also a high school, lordship. So otherwise that proviso would not be required, lordship. Because that proviso was given to facilitate those persons, lordship, those assistant headmasters who already, lordship, completed 15 years of lordship teaching experience in the graduate scale of. And admittedly, petitioner since 1991 receiving the lordship graduate scale of pay, lordship, and holding the post of assistant headmaster. So I am not in the lordship cadre of.
See, the respondent number 4 is appointed person to order being passed by this court in WPC number.
No, because ultimately the matter was remanded back, lordship. No final decision was given by this honorable court, lordship. This honorable court remanded the matter, directing the director, lordship, to take decision, although earlier appointment was cancelled, lordship. But the director, lordship, required to take the view, lordship, regarding that proviso, lordship. Otherwise, 15 years experience not required at all, lordship, because 10 years is enough, lordship. Only proviso was given to facilitate the lordship assistant headmaster, lordship. Because this honorable court, while setting.
Question is whether that proviso is applicable to the present or not, the respondent private respondent number 4 or not.
That would not be applicable for respondent number 4, lordship, because that proviso is for the teachers who came from the ME or MB school, having 15 years of experience in the graduate scale of pay. And here, lordship, the question is regarding only in-charge headmaster, lordship, not the regular headmaster.
Right.
Yes.
He possesses the requisite qualification and according to the director has passed the order.
And
But the director himself saying that he did not taken the NOC from the authority. So
No, their affidavit.
Your Lordship, paragraph 4.
At the time of pursuing BA degree, the school was venture state, was in venture state. That's
my lord, the school was provincialized with effect from 1/1/2013.
paragraph number 7. Of
Yes.
the affidavit in opposition filed by respondent number 2.
My lord, may I turn to page 32 of my page 31 and 32 of my writ petition, lordship, where the because he obtained the B.Ed degree in the year 2015, lordship.
Yes, sir.
And the school was provincialized with effect from 1/1/2013, lordship.
No, the affidavit indicates that he obtained it in the year 2012.
My lord, your lordship, may kindly.
The school was in venture stage.
My lord, school was not at the venture stage in the year 2013, lordship, because I have annexed the.
2012.
My lord, your lord, because this is the lordship certificate of respondent number 4. Your lordship may kindly turn to page 32 of my writ petition, lord, where I have annexed the certificate of B.Ed degree of the respondent number 4, lord, wherein it is clearly reflected that in June 2015, lordship, he passed the lordship that B.Ed degree, lordship. Page 32 is the main original one, lordship. And certificate was issued on 7/8/2015, dated 7/8/2015. So in the year 2015, he obtained, lordship, not in the year 2012, lordship. And the school was provincialized in the year 2013. 1/1/2013. So naturally, after 1/1/2013, Lordship, he became the permanent employee of the government of Assam, Lordship. So thereafter, he would require to take permission from the.
But have you filed any reply to this affidavit in opposition?
Lordship, oh, I'm extremely sorry, Lordship. I have not filed, Lordship. I may be allowed to file a response. Lordship.
After hearing length of argument, your lordship, he was now praying for time, your lordship, to file his affidavit. And in my affidavit, it is clearly stated that the after initiate department proceeding against the respondent number 4 for obtaining B.Ed degree without violation. In this respect, your lordship, deponent begs to state that upon the death of existing headmaster, so and so, your lordship, on dated 3/4/2020, the inspector of school, while later dated so and so, dated 4/5/2020, which is annexed as annexure 9, page 72 on continuation of the read petition, submitted the proposal along with seniority list of the teachers of the school for placing headmaster in charge in the school. Accordingly, the inspector of school, CDC Silchar, while later dated so and so 4/5/2020, annexure 8 to the read petition, temporarily allowed the petitioner to act as academic IC of the school along with MDM, that is midday meal, till the order of the headmaster received from Director Secondary Education. However, the inspector of school, CDC Silchar, had reserved right to withdraw the order at any time without assigning any reason, your lordship.
When the school was provincialized?
1/1/2000.
1/1/2013, Lord.
13. In my affidavit, that is paragraph 775, it was mentioned, your lordship.
Page 25 of my read petition, Lordship, I have annexed the provincialization order, Lordship.
Date of getting.
Receipt to Hasali.
আপোনাৰ টাইমত 15 years is necessary. মইতো ডিপাৰ্টমেণ্টক সুধি থৈছো। আপোনাৰ ভেঞ্চাৰ অলৰেডি আছে, তাৰ কাৰণে 10 years is necessary. এইটোৱে ক্ৰাইটেৰিয়া। এইটো আপুনি বুজা নাই, সেইটোৱে মোৰ দিগদাৰ হৈ আছে বুজাবলৈ। I am relying my কিয় নিদিব, নহবা এফিডেভিট ফাইল কেনেকে হ'ব? কপি চাৰ্ভ নকৰো।
Can let him file affidavit, will see.
My lord,
ultimately, truth has to prevail.
Matter he kept as part of
Kept part heard, your lordship, as it has heard in left.
Heard, sir, for doing a learned for the incident. And he does learn it's the thing for the secondary education part of part 4.
1, 2, and 3 I am appearing. আপুনি এতিয়া ফটো মাৰক, ফটো মাৰক দিয়ক। মই কিন্তু ৰখি নাথাকো দেই, অলৰেডি
He has not filed and replied by affidavit of by that part 2.
মই এইটো এটা টেনশ্যন আছে 29 ইমান টেনশ্যন আছে মই জানো।
And request for granting him some time to file his reply to the affidavit in opposition filing by the respondent. There is accordingly allowed. Face the matter after vacation. Mr. Borgia to file the affidavit in reply to the affidavit in filed by the respondent number on 5th of September. This is a less than matter as party.
Obliged.
Deeply obliged.
May I please, Lordship? This matter is relating to non-payment of gratuity and final pension. But on the last day, Lordship, not only last day, several occasions, Lordship, they took time stating that the proposal, that is a certain period, Lordship, during my service period, that was under lien, deputation. That period was not regularized. And because of that, my gratuity amount has been held up. And they have filed an affidavit saying that the department is going to initiate the process for placing the matter before cabinet.
May it be pleases you, Lordship. Here, Your Lordship, H. Terengpi is appearing on the last occasion, and Your Lordship, she is out of station. Kindly a short date may be given, Your Lordship.
My lord, this is the system. Sometimes my friend is appearing, sometimes Musahari, and sometimes this is the way, Lordship, they are taking time on it. In fact, Lordship, the petitioner, Lordship, retired in the year 2019. Gratuity amount, Lordship, this major amount has not been, Lordship, paid.
Okay, we'll grant you time, but pay some cost.
No, Your Lordship. A short date may be given, Your Lordship. Already communication has been made, Your Lordship, that
Communication has been made.
pertaining that, Your Lordship, to
Where is the
OM.
document to show that communication has been made?
2 OM is needed, Your Lordship.
Not necessary,
And Your
unnecessary
Lordship,
submissions.
and Your Lordship, it was reflected on earlier order, Your Lordship. Code
Unnecessary,
4.
they are insisting on the order of on the
It
official
was,
order.
it
is not in
it was given direction by the Honorable Court, Your Lordship. It was not given.
So why you are not producing? He did not annex with the affidavit.
No, Your Lordship, that affidavit was not filed by me, Your Lordship. And on the last occasion, Your Lordship, I'm not appearing, Your Lordship. So, Your Lordship, kindly a short date may be given, Your Lordship. Already communication has been made, Your Lordship, Kokrajhar, Your Lordship.
On the next day, another one will come.
I'll be appearing, Your Lordship. Kindly my name may be reflected in this matter, Your Lordship.
Next month,
Yes, Your Lordship.
It does current. Mr. Barua for respondent number. Mr. Barua for
5 million. We have not received that because due to not finalization of that particular
Mr. Barua for respondent number 6 and 7. Anybody? Depokan for elementary education department. Is does learned council the secretary department that this matter was earlier assigned to Ms. H. Karampi, but Ms. Karampi is absent today.
Next Monday, Kiman Hugo.
Price for this matter.
22.
After a
Monday is
week,
22.
Requested to reflect her name in the comments.
Yes, sir.
So that
More
any
appropriate.
update necessary. There is according to law, necessarily the method on 22nd.
22nd.
Oh, second.
I'm deeply obliged.
May please, Your Lordship. This case was fixed today for consideration of interim order, Lordship. Consideration for interim order, this case was fixed today, Lordship.
My lord, may I please your lordship? Lordship, here I have received some instruction. As per this instruction, my lord, he has already appeared before the committee, my lord. My lord, kindly see this.
Yes, this is, I have also stated, Lordship. I have already appeared before the authority, Lordship. But what happened in this case? In this case, Lordship, personally, which case?
Final outcome of the departmental. Final outcome of the committee, my lord, I have not received, my lord.
In
So
this
kindly
case,
some time may be allowed.
petitioner was arrested in a connection of a police case. Subsequently, after completion of the investigation, Lordship, petitioner was exculpated from the charge, Lordship. He was acquitted from the charge. In the charge sheet, this is mentioned, Lordship. Pursuant to this police case, Lordship, the disciplinary proceeding is going on, Lordship. This is our prayer, Lordship.
Report back.
Already he was acquitted, Lordship, during the investigation of the case, Lordship. charge sheet we have annexed, Lord.
You are challenging the departmental process.
Challenging departmental proceeding, Lord. Based
So
on a
is it not maintainable?
maintainable, Lord.
Then
No, Lord. See, writ petition is maintainable, Lord.
whether the departmental proceeding can go on, even
Lordship, this
Proceeding is going.
departmental
acquittal,
proceeding,
even in the case of acquittal of the petitioner in criminal case.
the departmental proceeding which was initiated pursuant to the police case, Lordship. This is the only allegation. He was arrested in a police case. Police case, Lordship, the petitioner already exculpated, Lordship, from the
Maybe.
proceeding.
Even then the authority can
There is
proceed
no
against-
allegation against him, Lordship.
Pardon?
There is no allegation against him in the police case, Lordship. He was already released from the police case.
Your affidavit is not available.
They have also not filed any affidavit, Lordship, in this.
Can be some time, maybe allowed.
Exculpated, released, acquitted.
Or APT scorecard? APT?
APT have not.
Learned to-
Short date may be given, Lordship. DP is going on already.
Substance. If they got time, file affidavit. Where alone?
Date may be fixed, Lordship. Before vacation may be.
The vacation man.
Interim may be considered under the next date, Lordship. This observation may be.
22nd.
Interim order may be considered on next date. Obliging.
Tata Institute Social Science admission matter, my lord. They were respondents were also filed an affidavit. Lord, affidavit has not been filed so far.
Lordship,
And,
Mr. Didas, senior advocate, Mr. Didas is leading this case. So today he has certain difficulties not in town. So I pray the matter may come up on Monday because he has urgency, I understand. But matter may come up.
Can you defer tomorrow, my lord? Because classes
We'll
are
file
going to
the
start.
affidavit.
Classes
No,
are
we
going
have
to
received
start.
the instruction.
Whether he gets it or not, he doesn't get it,
No,
man.
Because by Wednesday he cannot get an interim, he get a seat because the seats are all filled up. And the subjects that he had applied for is not the subject he's seeking for now admission. So these are the things that we'll bring by affidavit. So if your lordship fix the matter on Monday, in the meantime we'll file the affidavit.
The other day, we have asked you whether the petitioner can be accommodated.
That they are talking, not in the present number of seats, but they are talking with the administration. So Mr. Das will apprise you
How long it will go on?
by Monday, your lordship. Let him apprise your lordship. Satisfied. In the meantime, we can file the affidavit also.
In fact, my lord, what has been
Only,
submitted?
only accommodation for today. Your lord.
Okay, we will take it up on Thursday.
Thursday, man.
Thursday.
Deep level.
Your lordship, I've been informed this because say affidavit will have to be signed from Bombay, and Monday, I think Monday he is available. If Monday, because if he gets on Monday also. Because then Mr. Didas will be here, then we better if
My lord, let's
already-
see this, my lord. There are vacancies, my lord. Let's see this, my lord. This is, my lord, the last my lord, non-CUET examination that was held, my lord. There are for the Northeast there are 17 vacancies. Only 4 have been filled up. And my lord, lordship may see the last line, that is very important. So therefore, my lord, then my lord, a seat may be kept vacant, my lord. If they want, my lord, on a later date. So we'll see, my lord. This is the result sheet of the merit list, my lord, for the Northeast quota. My lord, there are 17 vacancies, my lord. I have shown, my lord, in the writ petition. 4 have been filled up, rather selected, my lord. Page 31 of my writ petition, 17 vacancies were there. Now, my lord, merit list is of 4, my lord. And the last paragraph, candidates from the rest of India, non-Northeastern states who have appeared in the non-CUET entrance examination are advised to regularly check that institute websites. They may be considered for admission later stage subject to available vacant seats. So 4 seats have been filled up out of, my lord, 17 vacancies. 1 seat may be kept vacant, my lord, if they want a longer time. Otherwise, my lord, if the seat goes, my lord, everything becomes infructuous.
It depends on what subject he's applied to. Not 17 seats, he's my learned friend is going on stressing, but he is applied to. So that we want to apply, bring on record the applications that the 3 subjects that we applied.
So those he is not eligible. And the for on-spot admission that he was called for was on a different subject. He didn't choose that subject. He wanted the different subject to which he has not applied for. So what I am praying, Your Lordship, is that let the matter be on Monday, this Monday. So Mr. Das will appraise. In the meantime, you can file the affidavit also. And if the interim order is passed,
Mr. Sharma, you see, we have granted him sufficient time to file the affidavit.
or Your Lordship, I understand, Your Lordship, there is certain
And,
difficult.
Today was fixed on the basis of the
I understand,
made
but
by Mr. Dita.
In fact, the UGC notification is very clear. It says, my lord, for these admissions, my lord, even if you have not applied for the main course, you can be accommodated other course. What happened, my lord, here, during the Zoom examination, Zoom interview, I opted for this seat. Though I had, my lord, applied for another my lord, vacancy, my lord, that is in, my lord, social science, my lord, that is, my lord, MA in, my lord, social work. But then, my lord, in the Zoom, my lord, selection process, I opted for peace and conflict studies. That is permissible under UGC notification also. So what they are trying to say that I did not apply for the post is also not correct. Anyway, my lord, that's another issue. But then, my lord, the only thing is that's my only anxiety, my lord. As your lordship has rightly appreciated, my lord, is the matter of admission. That's the urgency. Otherwise, I will not have been objected to this prayer.
Actually, said to him the other day, we made it clear that we are not interested in your affidavit, but you manage the seat for the
that I will then.
No, we have
I
already
know.
communicated
So,
it
Miss,
on the other day.
yes. So, Mr. Das is actually having a word with them. So that he will apprise your lordship. Maybe that's why on Monday, if it's not difficult.
But let it be on Monday. Let him come with concrete proposal.
My lord, I don't. Otherwise, I will not object, my lord. Definitely, my lord. My lord, lordship will, my lord.
Let us hope for the best. Appearing on behalf of that the leaders had some difficult and could not remain as part of and the affidavit to being prepared and it does for a matter of Monday. That is accordingly announced.
Obliged.
May I please? My lord,
Sir,
yes, Tasir. I have.
Adoniya is absent today.
He absent, my lord. I talked with him over telephone just now, my lord. He told me that it was not allotted to him for today. So, my lord, I pray, my lord, it may be taken on Thursday, my lord. Some urgency is there at 2 p.m. Thursday, my lord. Because the post will be filled up by on 10th of October, my lord.
Heard Mr. Professor, Lord, I counsel for the none appears for the respondent on call. Press shall list the matter on Thursday.
Thursday at 2 p.m., my lord. It will
At
take.
2 p.m.
Yes.
In the event of non-representation of the respondent on that day, the court will consider directing the respondent to personally remain present for this court.
Bless us.
May I please, your lordship, the matter relates to compassionate appointment, my lord. The father of the petitioner died in hardness on 6/1/2014, and he applied for on the limit in the stipulated time, that is 5th of August 2014, my lord. And the matter was considered in DLC, and after that, matter has been sent to SLC, where it was rejected by that there is no vacancy. But as per the RTI, my lord, there is 115 posts till now, my lord. Pray for sending the matter to SLC, my lord.
Mr. Devi, you are here? What is the resolution of the SLC?
Non-availability of posts.
Page number.
Page number 23, my lord.
Detail number.
Page serial number 4. In the column Nagaon, that is serial number 4. Non-availability of posts.
So David,
Yes, Your Lordship.
even if the posts are not available in the concerned department, they can be accommodated in other departments also, as per the office memorandum.
Yes, Your Lordship. Yes.
Then why the case of the petitioner was not considered?
Lordship, it is not a matter of right on subject to the availability. On subject to the availability, the matters are considered, Your Lordship. Perhaps after going through all of the department also, they may not have found it. So, Lordship, since almost all of the matters had has been by Your Lordship has been remanded back, Your Lordship. So this matter may be subject to taking considering to all of the departments, it may be given a chance. That's all. In other departments, because here it is not specific that whether it was rejected in that particular department or after taking into consideration of all of the departments. No, page number is there. Unavailability of post.
23.
Yes, Your Lordship. Page 23. Because once it is forwarded by DLC here to governor.
Okay.
DLC forwarding it. 13. Because if it is forwarded by DLC with indicating a specific post, Your Lordship, so definitely in SLC there should not be that should not be the ground of rejection, or that should not be the DLC.
What is the resolution of the DLC?
DLC
13 page number and Excel 6.
13.
Minus with the meeting of the DLC is in page relevant is in page 15.
Page number? Serial number?
Yes, my lord, it's page number 15, last serial number 1, my lord.
Is number 15?
15, serial number 1.
Serial
The last column, my lord, last column.
Last column. Hafizur. Hafizur
Yes,
Rahman.
Hafizur now.
Hafizur. It is just they have said 9 posts. Total grade 4 vacancy equal to 18. Proposal received grade 4 equal to 9. So it was recommended accordingly. But on perusal, it seems that he was recommended for that grade 4 post, Your Lordship. On that page 15, the last D column, Your Lordship, grade 4 equal to 9.
Then what is the occasion to observe that due to non-availability of the post, his recommendation cannot be considered?
That it is things are done in such manner that nothing is specific, because grade 4
simply written non-availability of post.
they ought to have been a specific format. Such large exercise they have taken, but they don't have a specific format.
Lordship, may I submit it? If the petitioner's case was earlier rejected by the SLC after taking into exercise, after consideration of all of the departments, then there is nothing. But if that has not been done so, it may be the petitioner, as per the OM 1615, that particular clause, he may be given a chance. That is what I want to.
To the memorandum.
Yeah. OM 2.
Clause number
15, 15.
then the recommendation of the TLC is also not available in which category?
Yes, that is
Which
what.
department?
Oh, entire mechanism, Your Lordship, that hurdles a bit. Somewhere to, as I have submitted before, and also not even the date of death has not been enclosed. By no financial comparison, nothing. Now, which post they have been referred to, just recommended they have said. Whatever be so, Your Lordship.
Then we'll issue direction to file the matter before SLP again.
Yes, yes.
In terms of this clause number 15.
If the same has not been yet. Oblige, Your Lordship.
You can take it back after tomorrow or day after tomorrow.
Yes, that is disposed matter. I mean, since the petitioner has not annexed the OM in her petition, from disposed matter.
Okay.
Numbers 49 and 50.
Lordship, in this matter, the petitioner was the senior most professor of the Cotton University, and he was a full vice chancellor. Subsequently, he Lordship resigned from the post. Lordship, now we are claiming for the area salary, Your Lordship, which is entitled to. The last occasion, they were directed to obtain instruction, Your Lordship, on the issue of area salary. I have forfeited other claims because I have resigned and joined in another establishment, my lord, Tezpur University as first vice chancellor, Pokraja University.
No, on last occasion, I was directed to bring instruction. However, unfortunately, I have not received any written instruction. As per verbal instruction, they are discussing the matter regarding the release of the arrear salary. Arrear salary means the salary which the petitioner is claiming from July 2025 to December. July 2024.
December 2024 to July.
December 2024 to July, my lord. 25. Kindly, my lord, give me some time. I'll get some instruction. My lord. Otherwise,
as per your verbal instruction,
they are discussing the matter, my lord, whether
How
she'll
long?
be entitled or not. Otherwise, my lord, the case is that our stand in our affidavit was that since the petitioner has already attained 60 years, my lord, the petitioner got retired, my lord, and as per the stand of our affidavit, yes, my lord, as per that stand, my lord, the petitioner is not entitled to. However, my lord, the department is
retirement matters here.
sorry, my lord.
How the retirement matters here?
No, my lord, retirement, that is after retirement, my lord, the period which the petitioner is claiming, my lord.
Lordship, I received my salary till December 2024. Lordship, but abruptly they have stopped it. They have issued the order of withdrawal of my appointment. But Lordship, my appointment was in terms of their office memorandum, cabinet decision, wherein extension of 5 years have been given to the senior professors working in the entire establishment in the state of Assam. Benefit has been given to us, Cotton University, engineering colleges, and medical colleges also. In fact, medical colleges, seniority is still 70 years.
Lordship, but in our case, although I'm working, what they have done, first they have issued the order of withdrawal of my appointment. Then thereafter, they have abruptly stopped my salary from December 24. In the meantime, I've got a job, new assignment. So I have resigned the earlier one and Lordship joined in my new establishment in Pokraja University as the first Vice Chancellor, my lord. Now I'm claiming the benefit till from December 24 to 24/7/2025. Because till that period, I have done my duties, they have utilized my services. Lordship, now they cannot deny it, my lord.
And look, the fact of the matter is this, my lord. The petitioner was working as a officer under CAS promotion, my lord, in Cotton College. He got the CAS promotion when Cotton University came into it. My lord, Cotton University is made up of Cotton College and the erstwhile Cotton College State University. It came into existence in 2017. Those faculty members of Cotton College, erstwhile Cotton College, my lord, they continue to be government servants. But the university employees, that is, employees appointed by the Cotton College State University and Cotton University, they are within us. The government of Assam, my lord, has its own retirement age. It is not of the university. Since he was an employee of the government of Assam, he is governed by the government of Assam rules. My lord, into what my learned senior friend has relied on is a 2012 communication, my lord, of the government of Assam saying that they would increase the retirement age of professors of the medical colleges was specific, and the letter was marked to the universities at that point of time, not to the government director of higher education, because there was no professor in the government of Assam at that. My lord, the retirement age of the petitioner was 60 years. He retired on 31st of March 2024. My lord, in July 2024, my lord, his services, they was extended, my lord, in July 2024 with effect from 1st of April 2020. Now, the government realized its mistake and had withdrawn that extension order on 11th of November 2024. There was a status quo order passed, my lord, on 13th of November after the withdrawal.
No,
So
my lordship, subject to correction, your lordship, whatever I have stated on the affidavit, my lord, oath, I received the order of termination, order of withdrawal of wherein my appointment has been withdrawn, directed to be withdrawn after the status quo order passed by this honorable court. So it is nullist in the eye of law, since by the time the order of status quo came into operation, my lord. Okay. And your lordship, in addition, my lord.
Mr. Nair,
my lord.
But you have utilized his service.
No, my lord. He came to the office on his own, my lord. The status quo order is of 13th of November. It is not status quo ante. It is not a stay order. It is status quo as on today, as on 13th of November. As on 13th of November, as on 13th of November, my lord, his services had already been withdrawn by the government. What my learned friend is pointing out is a communication from us on 12th of November, which he received on 13th of November, saying that to hand over the documents, to complete the formalities. But that would not say that the services would be extended. My lord, the withdrawal order is of 11th of November. So as on 11th, there is no contract between the government of Assam and the petitioner. Thereafter, if he chooses to continue, my lord, that is on, my lord. We have many cases, my lord, when even after retirement, a person continues, my lord, the salary, if paid, is to be recovered. The salary cannot be paid. Now, my lord, that is, of course, for the government to clarify. But insofar as we are concerned, Cotton University, my lord, he acted as a pro-vice chancellor as well, professor, as well as a pro-vice chancellor. Pro-vice chancellor, my lord, is not a substantive posting, my lord. It can be, my lord, withdrawn at any point of time. It is coterminous with that of the vice chancellor. It is an optional post. So,
Lordship, before my learned friend proceeds further, may I take your lordship to the additional affidavit filed by us? The order wherein my order, lordship, appointment has been extended. It was of 31/2024. Lordship, the copy of the office order dated 12/2024, your lordship, prior to my retirement. Additional affidavit, page 44, my lordship, may kindly have a look.
Which petition? Which requisition?
In pursuance of the concurrence given by the Department of Higher Education by so and so for the post of professorship Cotton University, the services of Professor Ganechandra Wari, who is superannuating from services on 31/2024 is extended up to
Affidavit page number.
page 44, Your Lordship, annexure K.
Which requisition?
It's 5934. WPC 5934, my lord.
44 and except 2. Next.
Yes.
Lordship, in pursuance of the concurrence given by the Department of Higher Education by so and so for the post of professorship Cotton University, the services of Professor Ganechandra Wari, who is superannuating from service on 31/3/2024 is extended up to 65 years, subject to the approval of the Honorable Cabinet, provided that if such promotion of professorship is accorded as per UPC norms. That was the order of extension which has been issued prior to my retirement from service, my lord. Then thereafter, Your Lordship, the pay slip given by the Accountant General at page 45. From 1/4/2024, which I have received up till, my lord, November 2024, my lord. Then thereafter, abruptly, they have stopped my salary, my lord. It was not credited into my account.
My lord may read this along with page 21 of the report.
And Lordship, the communication which I have received, the order of withdrawal, annexure Q, page 54. Pursuant to the office order number so and so, dated 11/11/2024, since the services have been withdrawn by the government with immediate effect, you are requested to complete the release formalities. That is, when I have received on 13/11/2024 at 4:30 p.m. And Your Lordship, kindly note, my lord, I am an employee of the government of Assam since Cotton University is a government institution, His Lordship is aware of. Cotton College is a government institution, my lord. So, Lordship, before this order of withdrawal is issued, it should be backed by a notice, my lord. Natural justice should have been prevailed, my lord. I should have been issued an order of termination of withdrawal. Then the government is deciding to issue an order of withdrawal. So what you need to say, a show cause need to be issued in my against me, Your Lordship. Nothing has been done. On 11, and what I have received, my lord, speed post on 1911, then prior to that, 13/11, 4:30 p.m. By that time, 2 o'clock, Honorable Court issued the order of status quo. So, Your Lordship, at 4:30 p.m., order of status quo was in my favor, Your Lordship. It was operating, and I have continued as such till July 2025, my lord. Till I have resigned from the post, my lord. And I have annexed the peon books also that I was in job, my lord. Lordship, may kindly see peon book at page 56. Thirteen 2024. It was by Cotton University authorities, my lord. And I received the order of withdrawal via WhatsApp, Your Lordship, which I have received at 4:30 p.m. I have categorically make environment to that effect. Now, since they have utilized my services, it's not that without any authority of law, I have continued, my lord.
Now the government has to pay the amount.
Yes, my lord.
Pay your salary.
Yes, my
not
lord.
by the Cotton
Yes,
University.
my lord. Lordship, yes.
Mr. Das.
Well, give me some time, my lord. I'll get instruction.
Sometimes you have to pay the amount.
No, my lord, this payment of salary for that period is, my lord, because the stand taken by the government, my lord, is that the retirement age of the petitioner or retirement age of any employee under the government of Assam is 60 years, my lord. And that
But you have extended it.
that was withdrawn, my lord. And I have categorically stated.
Before the same thing withdrawn, whether any notice was issued to him.
No, notice was not required because, my lord, I have categorically stated in my affidavit that that was issued on the wrong premises that uh, the the government thought that the petitioner will be withdrawing salary from the Cotton University, not from the treasury, because when the Cotton College became Cotton University, my lord, government was on the impression that the the after 60 years, the Cotton University will take care of the petitioner, my lord.
There's a saying in Assamese, "Dui mohor juddhat birinar mittu," my lord. That has been happened to me.
Because when
It's a fight between Cotton
in Assam, my
University
lord,
and the government of Assam. I have nothing to say, my lord.
in Assam,
I'm an honest officer. All will reveal, all will vouch for me, my lord. I'm an honest officer, professor of the government of Assam, working in Cotton University diligently. I have a high repute, your lordship.
There is no quarrel. In fact, he was my professor. But the petitioner was my professor. No,
He is last person to get a penny without the work done, my lord.
In this case, it's not so simple. There are two aspects. The first, my lord, is the first writ petition has to be decided whether that withdrawal order is correct or incorrect. Only after that, the question of payment of salary will. First, that writ petition has to be decided.
Lordship, they say that my employment is illegal. Now they are saying my order of resignation was also wrong. They have to accept only one or the other, your lordship. They cannot go by both the ways.
Let us go one thing. Mr. Nair, you have filed your affidavit.
Applications are complete.
Yes, I have. Also, yes.
Because I have forfeited all other claims except the payment of salary for that period. For that period from November till July.
He has nothing to lose. He's now a vice chancellor.
Maybe. Oh. Why should he sacrifice the?
That has to be decided, of course. That has to be decided, my lord.
Then, though it is not your legal duty, it is your moral duty to pay the salary to him.
My lord, that's for the university, my lord. I pay my respects, my lord. He was a well-loved professor, my lord. He is, my lord.
Anyway, let us fix it for hearing.
Admission hearing. Admission. Leave it to your lordships because I'm working.
Immediately after vacation, my lord.
After vacation.
In the meantime, positively he'll bring instruction, my lord.
In the meantime,
My learned
I'll
friend.
get instruction, my lord, written instruction in the whether if the government is thinking to pay, my lord, then all the writ petition will go. Yes, my lord.
If not,
If not,
the
my lord,
honorable court is there.
then
Access
final hearing will be
jurisdiction.
required, my lord.
Part which we punya karena it's discuss learning something higher
education, my lord.
department. Mr. Nair for respondent number
3 and 4, my lord. Coordinator, sending of the coordinator.
Mr. B. Sharma for respondent number 5. Finance department. Anybody? No. Not except for the finance department. Mr. Das submits that he may be granted some time to obtain written instruction in respect of payment of salary to the petitioner. Paid is accordingly allowed. This supplies the method on
1610, can it be, madam? Yes, 1610.
23rd,
1610.
other matters take date from him.
Your Lordship, in item
Deeply
number
obliged.
33, I need to file an objection. There was a statement which has been made. So the affidavit has to come from France, Your Lordship. So may I pray 4 weeks time may be granted, Your
My
Lordship.
lord, I have some objection, my lord.
Take date from him.
This is my lord, part hard matter, my lord. And
I'm
he
not
has filed
denying it.
impleadment petition, my lord. Last occasion, your lordship said hard, he can fix it part hard, my lord. Impleadment petition, my lord, hearing. So what objection to the impleadment petition he filed, my lord?
He has filed an objection to the impleadment application, which I'm objecting. Now, there is a wrong statement that has been made. I have to put it on record by a correct statement. So therefore, I have been instructed to file an objection to rejoinder to that. So may I pray, I may get some time, Your Lordship. I'm not objecting to his keeping part out or something like that.
My lord,
Okay.
my lord,
He will
my humble prayer, it may be because before my lord vacation, my lord, maybe my lord.
I think 51, my lord.
before vacation already a lot of matters fixed.
I think 51, my
I
lord.
think may happen on that day also.
Yes.
But I think
Then
51, my lord.
Deeply obliged.
Suspension matter, my lord. He is under suspension since March, my lord, without any DP.
The matter was listed in the other week also, my lord. But today, my lord, due to paucity of time, it could not be possible. My lordship will kindly take up this matter on Wednesday, my lord, at 2 p.m., my lord.
Okay. Take it from him.
At 2 p.m., my lord, on Wednesday, coming Wednesday. God bless, my lord.
Okay.